Ladies and gentlemen, good morning and welcome to the third panel of this conference, which is also the final panel. While the first panel yesterday morning focused on the, I would say, rather visionary aspects of Compiler digitization, and the second panel focused on facts. I mean, relocating a company within the European legal space is a fact, where everybody is entitled to do so according to the treaties. The third panel today will focus on the exact legal consequences of this relocation, which is, in practice, basically what kind of applicable law will be applied then after a company has been relocated, respectively, if there was some trans-border transaction in the situation. This third panel, in a way, is also the most long-lasting and in a way also mature legal discussion, especially compared to the first panel, which has then also the effect, if you have a look, for instance, at the second presentation today, that these needs for reform are now ready to be implemented. And this is something Pierre-Henri Cognac will be presenting in his second presentation. The discussion itself will be first introduced by Professor García Martín from the University of Madrid, and will later, after the coffee break, be continued after by Professor Muysen from the University of Antwerp. Before then, finally, Professor Traversa will focus on the, at least from a German perspective, most horrifying part of company law here on tax issues. Yes, and I would like to give the floor already to Professor García Martín, who will talk on the law applicable to companies in the EU, the status questiones.
Well, thank you very much, Thomas. Thank you to the European Commission and to the Estonian presidency for inviting me to this conference. It's the first time I come to Estonia, and it's a real pleasure to be here. Well, the purpose of my presentation is just basically to set the scene for the rest of the discussion this morning. I'm just going to outline the conceptual framework for any future instrument on the law governing companies, on the law applicable to companies, and to point out the main policy decisions that the European legislators should make in this context. And for this purpose, I'm going to divide my presentation in two parts. First, I will describe the two main approaches to the determination of the law applicable to a company, the realcy theory versus the incorporation theory. And then afterwards, I will point out the main element that any future instrument in this field should contain, i.e. a policy decision on the big issue, which law governs a company, an option for the incorporation theory, the realcy theory, or a combination of both. Then the scope of the lex societatis, the scope of the law governing the company, and the relationship between the lex societatis and other neighboring areas, such as insolvency law or tort law. And finally, the regime on changes of lex societatis, i.e. whether and under what condition a company or the members of a company could decide to change the law governing their company. And in the second part, I will briefly summarize the European case law in this area. But before continuing, I would like to warn you about one thing, because probably the title is misleading. The way I understand it, the future instrument on the law applicable to companies doesn't say anything about the law governing the external activities of a company. Doesn't say anything about the company, whether a company has to pay employees, whether it has to pay wages, whether a company has to respect labor law, whether a company has to pay taxes, whether a company has to respect environmental law, whether a company has to respect human rights protection, financial regulation, or capital markets. The future instrument is basically limited to the internal aspects of the company. It's basically a private law instrument, not a public law instrument, not a regulatory law instrument. That's why I'm somehow puzzled by the argument which runs that since some kind of real seat is the dominant connecting factor in such areas as tax law, the central of effective administration, insolvency law, the central of main interest, labor law, the place of business, the same connecting factor should be used in company law. And I'm puzzled because precisely I draw the opposite conclusion. Since labor, employees, workers, employees, creditors, tax authorities are protected under all other rules, we should allow the party autonomy in this area, because this instrument focuses on the rights and obligations between the members of the company and the members and the directors of the company. So it's basically the internal relationship of a company, and therefore, if the rest of the parties, if the rest of the stakeholders are protected by other areas of the legal system, why shouldn't the parties that are affected by this area be entitled to choose the law they prefer? That's why I always draw the opposite conclusion and say, if on other areas the real seat is the dominant connecting factor, some kind of real seat, in this area my conclusion is that the autonomy of the party should be the dominant connecting factor. Just to start by reminding you the current situation in European company law. So far, European company law has developed at two levels. On the one hand, we have certain instruments establishing supranational companies, European companies, basically the Societas Europea, the European company, or the European Cooperative Society, which are entities created under European law, not under national law. And on the other hand, we have rules harmonizing substantive company law. Basically, not only, but the main instrument here is the recent directive 2017-1132 that has codified an important part of this substantive harmonization: minimum capital, contributions, distribution of benefits, mergers and disclosure, and so on. But even though we have this kind of substantive harmonization, there are still many issues that remain in the hands of the member state. So what this means is that at this stage, it is still important to determine which law governs a company. So the determination of the law governing the company matters in practice. Nevertheless, after the failure of the 1968 Convention, we don't have any European instrument determining the law governing a company. So operators in the market do not have a clear answer about which law governs a company. If they want to incorporate a company, under which law they must incorporate this company. Traditionally, if you look at the laws of the member states, there have been two classical approaches to solve this problem: the so-called incorporation theory and the so-called real seat theory. The incorporation theory, which basically says, is that a company is governed by the law of the place of incorporation, and the starting point is the autonomy of the parties. It's a subjective connecting factor. The parties can choose under which law they want to incorporate the parties, the company. And when I refer to the parties, I refer to the founders, the original founders of the company. On the other hand, we have the real seat theory, which says that in principle, the parties cannot choose the law. In principle, a company should be governed by the law where the real seat of this company, which is usually equated to the central administration, where the central administration of the company is located. And the contraposition between these two theories, and probably theory is not the right word, these two, but it's usually used, between these two theories is with regard to the problem of recognition of foreign companies. So let's imagine a case where we have member state A is the place of incorporation of the company, and member state B is the place where the real seat of this company is located. In that case, if member state B follow the incorporation theory, member state B shouldn't have any problem when recognizing the company incorporated in member state A. As long as this company has been validly incorporated in state A, state B could recognize and should recognize this company. Whereas if member state B follows the real seat theory, that company should not have been incorporated in state A, but should have been incorporated in state B. It's going to be governed by the law of state B, which means that since it has not been validly incorporated in state B, from the point of view of state B, that company should be qualified, for example, as an irregular company, and therefore the members of that company should not benefit from the limitation of liabilities, should not benefit from the principle of limitation of liability. That's why it has been said that the real seat theory is basically a theory of not recognizing foreign companies insofar as those foreign companies have the real seat in the foreign state, has the real seat in the host state, so to say. The classical, there's a long-standing discussion about the advantage and disadvantage of either of those theories, or the pros and cons of those theories. I just want to summarize this long-standing discussion. Basically, there are two main arguments in favor of the incorporation theory. The first one is that this theory promotes party autonomy. If the founders of the company or the members of the company in general prefer the law of member state A, prefer Estonian law or prefer English law, why shouldn't be entitled to choose that law? Under this theory, they could choose the law that better fits their needs. And since they are the parties who are going to suffer the main consequences of that selection, they have the right incentive to choose the better law. Not forgetting that we are talking mainly about the internal affairs of the company. We are not talking about external activities of the company. So these parties, this theory, allows parties to benefit from the legal diversity. And if in the European Union we have 28 different company law systems, why shouldn't operators in the internal market be entitled to choose the law they prefer? At the end of the day, the law governing a company, it is an implicit production cost. And the better the law is, the more cheaper the production of the cost of the company is, and therefore the more competitive that company will be in the market. So why don't we allow parties to choose the law they prefer? And the second main argument is that this solution provides legal certainty. It's relatively easy, or very easy, I would say, to determine the place of incorporation of a company. It's much more costly to determine where the real seat of the company is located. It is not easy at all, especially when we are talking about online companies, when we are talking about online meetings of the board of directors. It is not at all easy to determine where, or may not be so easy to determine where the central administration of a company is. And note that the central administration could change depending on external circumstances, such as the economic situation of the company. Each time that there is a change of the central administration, if for any reason the director of a Spanish company decides to move to London because the company has appointed a new director and a new board of directors, and the majority of the board of directors lives in London, now it is very likely that this company has to move the center of administration to London. And that would imply that the company has to change the applicable law, which, as you can imagine, it is not very practical. On the other hand, the main advantage of the real seat, it is usually invoked, is that the real seat prevents the founders of the company, of the members of the company, from choosing a law that benefits those members of the company at the expense of third party, basically at the expense of workers, at the expense of employees, or the tax authorities. But please, the effects on these third parties of this instrument is very limited, is very narrow. So basically, any future instrument in this area should include or should deal with three main parts, should contain three main parts. The first one is an option, and as clear as possible, an option for either of those theories, the incorporation theory or the real seat theory, or a combination of both, because probably there's no better theory in absolute terms. We should start with one theory and including certain limitations or certain exceptions, but that should be the first policy decision of any future instrument in this area. The second part should include the delimitation of the scope of application of the lex societatis, and as I have said, in particular, the relationship between the lex societatis and other neighboring areas, such as insolvency law and tort law. The starting point is very simple. Any future instrument should be limited, and that's the way I understand it, should be limited to the internal affairs of the company, to the contractual aspects of company law, basically to the rights and obligations between the members and the directors, to the existence of the company, and to the limitation of liability of the members of the company. Because when we say company of limited liability, the company has not limited liability. The members of the company are the ones who have limited liability. So these are the second main part of the future instrument. And the third main part should refer to the transfer of the real seat. I should clarify which connecting factor triggers a change of applicable law of the lex societatis or of the applicable law to the company, and whether and under what conditions this change is possible. And when I talk about changes of lex societatis, it is commonly referred by other participants as transfer of the seat abroad, reincorporation abroad. But personally, I would prefer to talk about changes of lex societatis, because I think that this idea more accurately reflects what we are talking about. We are talking about a change of the law governing the internal affairs of the company. And a change of lex societatis basically means that the parties can change the law governing their internal relationship without the need of winding up the company and liquidating the company in the state of origin and setting up the company in the new law. They can change the lex societatis, keeping the legal personality of the company. If you look at the European case law, it is true that the European Court has clarified certain aspects of these three issues, these three problems. On the one hand, there are an important set of cases dealing not directly with the law applicable to a company, but indirectly, as I am going to explain a bit later, that put important limits to member states with regard to which connecting factor determines the law applicable to a company. Second, there are a set of case law dealing also with the scope of application of the lex societatis, of the law governing the company. And thirdly, there are also an important number of case law dealing with the changes of lex societatis. Just to go a bit in detail with regard to this case law, the first issue is which law governs a company with regard to the law applicable to a company. And the starting point of the European Court of Justice is always very simple. A company is a creature of law which exists only by virtue of the national legislation which determines its incorporation and functioning. This idea that the companies are creatures of laws, creatures of national law, and they only exist insofar as they have been recognized by national law. And probably this idea, which is a mere metaphor, we should not forget that this is a metaphor. And it could be, first, I don't think it's even true, and it could be said of any other legal institution. A contract is only a creature of law, it's only exists insofar as it can be recognized by law. But it is true that this probably starting point is necessary since the European Court of Justice has addressed this issue from the point of view of the freedom of establishment. And at the end of my presentation, I would try to argue that there's another viewpoint or another point where you can, from which you can analyze these issues. By definition, under the context of the European Court of Justice case law, this is the starting point. And as a consequence, it has two main consequences. Since this is the starting point, it has two main consequences. The first one is with regard to the member state of origin. If a company exists only insofar as it has been recognized by a national law, it is for that national law, for the home member state, to determine which conditions a company must meet to be validly incorporated under that law. So it is for English law to determine which conditions a company must meet to be incorporated in England, or it is for Hungarian law to determine which conditions a company must meet to be incorporated in Hungary, including the location of the real seat. The member state or the state of origin could keep the real seat as a condition for being incorporated under that law. So Belgium or Hungary could say that if you want to be incorporated in Belgium or you want to be incorporated in Hungary, you must meet Belgian law conditions, you must meet Hungarian law conditions, but you must also place your real seat in Belgium or in Hungary. And therefore, the real seat is maintained, in principle, is not incompatible with the freedom of establishment from the point of view of the home member state. And for the same reason, the home member state may decide that if you want to keep this law as lex societatis, if you want to keep this law or this state as a state of incorporation, you must keep the real seat within the territory of the home member state. If you transfer your real seat abroad, you lose the home member state nationality. You lose the possibility of keeping the home member state as a state of incorporation. However, once a company has been validly incorporated in the home member state, in accordance with the conditions of the home member state, the principle of mutual recognition applies. And therefore, the rest of the member state must recognize this company as a validly incorporated company. Or in other words, in the context of the freedom of establishment, the non-recognition of a company validly incorporated in another member state is an obstacle to the freedom of establishment. Or in a positive sense, using the words of the European Court of Justice, the recognition of a company validly incorporated in another member state is a necessary precondition for the exercise of the freedom of establishment. And therefore, as a consequence, for those states that follow the real seat theory, the non-recognition of a company validly incorporated abroad is an obstacle to the freedom of establishment and basically is against the Treaty of the Functioning of the European Union. It's against Article 49 and 54 of the treaty, which means that the treaty has a strong influence in those member states that follow the real seat. It means that you cannot keep the real seat as a reason for not recognizing companies incorporated in another member state. Probably the main policy principle of the real seat is against the European Treaty, and I think it's important to underline this. As a consequence, the treaty protects the mutual recognition of companies validly incorporated in another member state. With regard to the scope, the European Court of Justice has also clarified that you must recognize a company validly incorporated abroad, not only the legal personality of that company, and it was clearly defined this idea or formulated in the Overseering case and the Spiral case, you must recognize not only the legal personality of the foreign company, but also you must recognize the lex societatis of the foreign company, i.e., you must recognize that that foreign company incorporated in another member state is governed by the law of the member state. So it's an obligation to recognize foreign companies as such, i.e., to recognize foreign companies as governed or as companies governed by the law of the home member state. It is true that the European Court of Justice has recognized the possibility of including certain limits. You can deny the recognition of certain aspects of the lex incorporationis, of the lex societatis. However, those limits must meet the Gebhardt test, i.e., they must be aimed at protecting general interests in a non-discriminatory manner. They must be suitable to attain their objective they try to achieve, and they shouldn't go beyond the protection of this objective. So it is the proportionality test. They must be the less restrictive measure to attain this objective. And the European Court of Justice has applied this test to important elements, such as the rules on minimum capital, the obligation to disclosure, director liabilities, and in all those cases, the European Court of Justice has rejected that any limitation to the recognition of the foreign lex societatis, to recognition of the foreign company governed by a foreign law, is not justified under the Gebhardt test, is not justified under the treaty. And I would like to point out those two arguments that for me are essential to understand the reasoning of the European Court of Justice. And I think that this argument can be generalized. This argument could be applied not only to companies incorporated in other member states, but also to companies incorporated in third countries. And that's why I think that the incorporation theory should be the main option, not only for companies incorporated in another member state, but also for companies incorporated in third country. The first argument, I think, is quite persuasive. The first argument says that the real seat theory is not suitable to attain the objective of protecting creditors, because in this case, it was the Centros case. You remember it was a company incorporated in England. The place of business of this company was Denmark, so the activities of this company were carried out in Denmark. And the argument, one of the arguments of the commercial register in Denmark was that Danish authorities should not recognize that company as an English company in order to protect local creditors. And the Court of Justice says, are you telling that if this company would have located the central of administration in England, even if the company maintains the activities in Denmark, in that case, you would recognize the English company? This is quite surprising because Danish creditors should be exposed to the same risk. So what the Court of Justice says, there is no direct relationship between the location of the central administration and the protection of their creditors. And it's the same with regard to third countries. We say, we don't recognize a company incorporated in Bahamas if the activities of the companies are carried out in Spain. Because we want to protect, well, this is not the case of Spain because we opted for the incorporation theory, but let's imagine, I don't know, Hungary. We don't recognize a company incorporated in Bahamas in order to protect Hungarian creditors. But if the center of administration is located in Bahamas, we do recognize that company, even if the company maintains or keeps its activities in Hungary. And for me, this is not a very convincing argument because there's, as I said, there's no direct relationship between the location of the central administration and the protection of creditors. And the second argument is the principle of volenti not fit injuria. I mean, nobody is obliged to enter into a contract with a foreign company. As long as there is clear disclosure of the nationality of a foreign company, any creditors, in principle, leaving aside tort creditors and public creditors, but in principle, the majority of the creditors that enter into a contract with a foreign company, they know that they are contracted with a foreign company and they must assume the consequences. They must assume the consequence that the counterparty is governed by a foreign law. And finally, with regard to the changes of les societatis, this is an issue that was thoroughly discussed yesterday. I'm just going to point out 2 or 3 ideas, main ideas. The first one is the starting point. The starting point is very simple. The state of origin determines which connecting factor triggers a change of les societatis, which transfer of the connecting factor triggers a les societatis. So it is for the state of origin to determine whether the transfer of the registration office abroad and or the transfer of the real seat abroad implies a change of the les societatis. And it is for the state of arrival, for the host state, for the new state, to determine which condition the company must meet to be incorporated in that state, and whether the company must also locate the real seat in that state of reincorporation or state of arrival. And now we can differentiate 3 different scenarios. The first scenario is when both the state of origin and the state of arrival follow the registration office. They are purely registration office, so to say, states. In that case, the only element that triggers a change of les societatis is the transfer of the registration offer. A change of les societatis only takes place by voluntary agreement of the members of the company, because a transfer of the registration depends merely on the voluntary of the member states, of the members, sorry, of the company. So they can change the lex societatis irrespective of what they do with the real seat. They can move or not the real seat. In this first scenario, it is true that probably the freedom of establishment does not apply. When we are talking only about changes of registration office, without any movement of the economic activity to the state of arrival, we could argue that there's no real freedom of establishment involved, as General Advocate Kokot has argued in the Polwood case, and therefore these changes are not protected by the freedom of establishment. And I'll come back later to this issue. The second scenario is when the state of origin follows the real seat theory. In this case, a change of les societatis only takes place if there's a movement of the real seat, or in other words, if the members of the company wants to change the les societatis, they have to move the real seat abroad. They can do it, but it is obviously more costly than a mere change of the register office. And in this second scenario, there are 2 problematic situations. The first one related to cases where there's a transfer of only one of the elements. First one is when we transfer, or the company transfer only the real seat, but wants to keep the register office in the state of origin, is the Daily Mail case or the Cartesio case. In this situation, the European Court of Justice has said that the freedom of establishment does not protect a mere transfer of the real seat abroad. And the other scenario is the Polwood case, where the parties want to move the register office while keeping the real seat in the state of origin. And we are waiting for the decision of the European Court of Justice, but the Advocate General Coker has said that a mere change of the register office is not protected by the freedom of establishment, which for me and I think for any practitioner, it's very difficult to understand. Because what we are basically saying is that you can carry out that by a mere cross-border merger, i.e. by setting up a subsidiary in Luxembourg and carry out a reverse cross-border merger. So you can do that indirectly, but you cannot do that directly. So it is weird to explain to a non-expert in European law, say that European law gives you the opportunity to do it indirectly by a reverse cross-border merger, but does not allow you to do it directly. Even if it is not protected by the freedom of establishment, I think from the point of view of the consistency of the European law is very difficult to accept. And the third scenario is when the state of incorporation, of reincorporation, the state of arrival follows the real seat. And in that case, the answer is very simple, is the valid case. The state of reincorporation must require the company to locate the real seat in that state. And if the parties transfer the registered office to the state of arrival and transfer the registered office to the state of arrival, in that situation, the state of arrival, insofar as it recognizes the possibility of internal or domestic conversion of companies, it should also recognize the possibility of cross-border conversion of companies. This is the valid cases, I have said. And just by way of conclusion, first idea, the European Court of Justice case law has reduced the uncertainty, or has partially reduced the uncertainty with regard to determination of the law applicable to a company. At least it has clarified that the real seat from the point of view of the host member state is incompatible with the treaty, which is very important. Once a company has been validly incorporated in one member state, the rest of the member state must recognize that company as such, as a company of the state of origin, even the member state where the real seat of that company is located. However, I think, or I believe there's a lot of uncertainty surrounding this area. In principle, this approach is based on the freedom of establishment. It's not approach based on a pure conflict of laws system. It doesn't harmonize the connecting factor determining the law governing a company. Secondly, the determination of the scope of the lex societatis requires a case-by-case analysis. It is true that the European Court of Justice has given certain principles, but there's not a clear legal instrument determining the scope of the lex societatis and its relationship with other neighboring areas, say in particular torts and insolvency. Cross-border transfer or cross-border or changes of lex societatis are difficult in practice, as we have seen in the panel, in the discussion yesterday. And also, there are no rules with regard to the recognition of companies incorporated in third countries. And I think this is going to become a key issue after Brexit, because as we all know, there's a huge amount of economically European companies that has been incorporated in London. And just one last minute, since it seems that we academics are entitled to finish or to wrap up our intervention with a reference, I would like to refer you to the proposal presented by the European Group of Private International Law. It is a proposal of a draft instrument on the law applicable to companies, and the basic idea of this proposal is the following. We can, and it goes back to one of my ideas, we can approach this issue from two different perspectives. We can approach this issue from a pure freedom of establishment perspective, and this is the approach taken, it could have taken another one, is the approach taken by the European Court of Justice, but we could also take a different approach, and we could also take a more conflict of laws approach. And in that case, the legal basis for the future instrument should not be Article 49 and Article 54, it should be Article 81. And for me, it makes a lot of sense, and I guess for the rest of the members of the European Group of Private International Law, we understood that it was preferable to follow this second approach, and this second approach based on the simple ideas. In principle, the parties, the members of the company, since we are only dealing basically with the internal affairs of the company, the members of the company should be able to choose the law they prefer, not only within the European Union, but also with regard to third countries, because basically we are talking here about contractual relationship, and it's something that has been said by the European Court of Justice. We introduce certain limits aimed at the protection of third parties, but the starting point is that in a purely conflict of laws approach, the parties should be entitled to choose the law they prefer, and should be entitled also to change the law. I see no reason why if I'm a founder of a company under Spanish law, and I come to Estonia, and I listen to you, and I decide, oh, Estonian law is much better than Spanish law, why shouldn't I be entitled to change into Estonian law, even if I want to keep my activities in Spain? As I have said, these changes of lex societatis, if it is in the benefit of the company, it reduces the indirectly or the implicit cost of production of companies, and therefore it makes companies more competitive. So that's my last comment. Thank you very much for your attention.
Thank you, Professor Garci-Martin, for this indeed very instructive presentation. A presentation which I'm sure certainly will also assist the audience to make up their mind during or in the framework of this panel's poll, which is online again. For those who do not know the address is also printed on the program on the back. And it does not come as a surprise that it will focus on the incorporation and real seat theory. Our next presenter is Professor Pierre-Henri Cognac from the University of Luxembourg. He is Professor for Commercial and Company Law, and he will present the outcomes of the study by the London School of Economics in 2016, an outcome where I'm actually also personally interested in, as I contributed the Estonian country report to the study. Professor Cognac, the floor is yours.
Okay, thank you for the organizers for the invitation to the conference. And today I will be presenting my presentation, so it will be easier for me. So I've been asked to present this London School of Economics study on conflict of laws, which I've named towards the Crossborder Transfer of Seat Directive under Rome 5 regulation. So my presentation will include essentially two parts, introduction, conclusion, obviously. And I will gather in the first part what is scattered in the study, which is statistical data that they gathered, so quantitative data, empirical survey, so they made a study where a qualitative study, and then they came with a comparative analysis about the different rules in the member states. And then they come to conclusions, which is the normative analysis, and they come with some proposals, essentially that we should have a cross-border transfer of seat directive, and also what they call a Rome 5 regulation, which means full regulation, sounds like Professor Garci-Martin has suggested, which will deal in Europe on all issues relating to conflict of laws for companies. So let's start with, in 2011, with the report of a reflection group on the future of EU company law. So I'm mentioning this report because I was one of the members at the time, and where we discussed many different topics, and also these topics of conflict of law, real seat, and this kind of ideas. So what was in the report? Well, essentially you had two elements. The first one was there was a very strong support for a cross-border transfer of seat directive. It was unanimous. Everybody was asking for it. And it has been asked and asked again since many years, actually. So it's really something which comes back. So it was not a real issue. But at the same time, we decided to look a bit at this issue of conflict of laws, because some people said that there are problems. Of course, there are some problems. And the idea was, okay, that in this reflection group, some people thought that it was time to think about a EU regulation, like has just been proposed, about conflict of laws. But no, you need a study. You cannot just say, well, we think there's an issue, we need a regulation now. So the idea was, okay, let's make a study. And there was also another recommendation from the report, which said that there should be a study on the real seat, whether it was a good or bad idea to have a real seat. And the thinking behind the reflection group was, I have to say, hostile to a real seat approach. The reflection group was quite liberal and thought that the incorporation theory was much better. But there was a full recognition that, it's up to the member states to decide whether or not they want to have the real seat or the statutory seat. So the idea was more to say, well, why don't I have a study on this, First, to see if there's an issue, if there's a problem, and therefore, if there's a problem, maybe you need some regulation on conflict of laws. Also, maybe to enlighten the member states about, well, maybe the real estate is not so good. So the EU Parliament came in 2012, was a resolution which had been proposed by Klaus-Heiner Lehner from Germany, CDU, and he supported this idea to develop some kind of regulation at the EU level on conflicts of law. But I have to say, this was in 2012. Klaus-Heiner Lehner left the EU Parliament after this, so I cannot assume, that the EU Parliament will be as such in favor of this idea. It's a new EU Parliament now, and therefore, this was the idea at the time. In addition, Klaus-Heiner Lehner was a very, strong supporter of EU company law. Now he's gone. So it's another legal committee, and so this exists, this resolution, but it cannot be, taken as, valid law in a sense, You have to ask the EU Parliament. Then there was a public consultation in 2012 also, and this consultation showed some support for rules on conflict of laws. Then you had the action plan on company law and corporate governance in December 2012, and there was no reference to conflict of laws. But I have to say, this probably has to do with the fact that the action plan was prepared by the unit in the Commission who is in charge of company law, and not the unit in the Commission which is in charge of conflict of laws. So obviously, this is a division within the Commission, and this is just normal that they will not, let's say, spill over in the area of the other unit in the Commission. So this idea of harmonization of conflict of law rules came back again, with another public consultation in 2013, and it showed on cross-border, was a consultation first on the cross-border transfer of seat. And the answer, I'm sure you all remember, was overwhelmingly positive. Everybody said, yes, please. Well, almost everybody said, yeah, please, do a cross-border transfer of seat directive. We have been waiting for this since 20, 30 years, more or less. But the proposal was, despite this strong support, proposal was disappeared, and I have to say for political reasons. There was no political consensus. Of course, if you have no political consensus, it's no point, to come with a proposal. Now we come to the London School of Economics study. So this study was ordered by the DG contract law unit, so not the company law unit. So the unit was in charge of conflict of laws, not the unit which is in charge of company law. So another unit which is used to work with conflict of law issues. And this study, so I was part also of the steering committee. I made also a report, but I didn't draft it. So I'm presenting it, but I have to say I don't share as such, all the conclusions. The report was drafted by 4 colleagues from the UK, but I have to say this study, which is 350 pages long, so it's really a tough reading. It's excellent. I mean, the quality of the work is excellent, I have to say. You really think a lot about it. I don't mean I share all the conclusions, but I have to say, well, it's really something which is extremely valid in terms of, thinking. Then you have the GDIP proposal, which Professor Garcia-Martin has just presented in 2016, which basically goes in the same direction and says, well, we need some type of new Rome regulation, essentially, on this issue. So now Commission made in 2017, issued in 2017, public consultation, which was this time targeted at the issue of conflict of law specifically. So do people want, conflict of law regulation in company law? And the results are not, here, are not public yet, so we have to wait. But it would be interesting to know what people say, because, now the question is really asked in a very clear way. Do you want a Rome 5 regulation, essentially, So we have to wait for the answer. If you take the study, it's divided in 4 parts. So as I mentioned in the introduction, so statistical data, they gathered data, which are interesting. Empirical survey, they ask people to answer questions. Are there any problems in this field? They made a comparative analysis, which is quite rich, and they also came with normative assessments, so that the proposal. They say this is what we will propose as a regulation, if the Commission was interested, to move in this direction. But to boil this down, I will say you have essentially three issues, in this report. First issue is, do we need a directive on cross-border conversions or transfer of seat? This is the first issue, which is dead in the report. And the second one is the conflict of law issue. So there are differences among the member states about how they look at conflict of laws in company law. And the issue is this one. Do these differences create problems in terms of multiple application of various laws which will make the life of companies impossible? If the study says yes, the life of companies is difficult because of this multiple application of different laws when you have a company which is in two countries at the same time, well then, in such case, we might have to do something which could be either a regulation which will deal with everything, which will deal with the conflicts of laws among member states, so within the EU, but could also look at an harmonization between the member states and third countries. So these are the questions, So there are essentially two issues, in this report. Do we need a cross-border conversion directive? And do we need some kind of regulation on conflicts of laws because there will be some problem? So we have to look now at the evidence, they came with about whether or not there's an issue here. So first, we start with statistical data on foreign incorporation. Their study is limited to private limited liability companies. So this is the UK private limited companies. This is the German Austrian Gesellschaft mit beschränkter Haftung. This is the French Luxembourg SARL, Belgium SPRL, and so on. So it just focused on this type of companies because experience has shown that there's been a lot of activities with this. And we all remember, the UK creating a lot of companies which were basically German companies because of the issue of legal capital. In order to create this statistical data, they try to identify what is a foreign company. What is a company which is incorporated in country A, but which has its real seat in country B, like a private UK company incorporated in the UK, but run from Munich, for instance. And they came with this idea that, they would look at the nationality of all managers of a private limited company, and they couldn't, because they couldn't check the residence, apparently. But it's not the same, You can be, German national living in UK. So it doesn't mean you are a foreign company, but anyway, it's better than nothing, I would say. And when I look at the study, I have to say, they might have a bit underestimated the phenomenon. Because I remember a study by Professor Teichmann and Kneier about foreign corporations between Austria and, Bavaria. So some people in Austria will create companies in Bavaria because at the time, Germany had the Unternehmergesellschaft, which is a kind of simplified GmbH, with very limited capital. So some Austrians thought, okay, why not create, a company just across the border in Bavaria? It's very close by. And therefore, we would just enjoy the €1 capital instead of, at the time, I think it was 10,000 euros in Austria. So this was the same phenomenon, as German companies, Germans creating UK companies because they wanted the €1 capital. And this existed, there was a lot of companies, but it doesn't appear in the study. So I'm a bit surprised, and I wonder if I have not underestimated, a bit the phenomenon. But still, they come with, UK is, of course, pops up, as a country where you have a lot of foreign incorporations. But I think the phenomenon is much wider than what they could identify through data they got from the registers. Okay, so what do we discover here? Well, no surprise. UK is the place where you have many foreign incorporated companies. So companies incorporated in the UK, but the real seat is not in the UK. The real seat is in Germany, the real seat is in Ireland, the real seat is in Netherlands, wherever. But they're not the only one. You have several member states in Central and Eastern Europe. We also host many foreign incorporated companies. So this is Estonia, for instance. I'm not surprised, when you see at the efficiency of a business register, well, why not create your company in Estonia? It's so easy, 18 minutes, you know, everything in English. You have, you know, articles of incorporation, which are standard. I mean, it's a very attractive proposal. You know? But Romania also apparently attracts people, and Slovakia. Most foreign incorporations occur among neighboring member states. So Austria, Germany at the time, where they had this UK in Germany, but now I guess in Austria the issue is solved because the level of new capital has been reduced. You had also clusters. So for instance, Estonia, Latvia, and Finland are an area where you have a lot of it's cross-border companies, essentially, so foreign incorporated companies. So I assume many Finnish create their companies in Estonia, same thing with the Latvians. So they're aware of the system and they benefit from it. And what they also showed from the study is that all this, let's say, development of foreign incorporated companies is not so much linked to the development of ECG law. So they say it booms much after ECG law has been developed. So it's not just linked to the development of the EU law. So it's not when you have one decision that suddenly it pops up. It starts much earlier. Now we move to the qualitative part of the study, and they send studies to lawyers in the member states, and they got some answers. So 177 people answered. It's not that much, but at least you can look at this. And what does the study say? Well, lawyers, they complain. They say, on cross-border issues, on conflict of law issues, our national law is not clear enough. The ECG case law is not clear enough. Yes, this makes sense. What the ECG says is, well, you can move your seat from country A to country B, but it doesn't say, how you do it. So it all depends on the national legislation. So they essentially complain, and they say, well, the system is fine in theory, but it doesn't work so well in practice. So we would like to have some, EU action at this level. And what you can see is you have some people who say, well, countries where you have a real seat, they're the ones who are the most willing to have an EU intervention. Why? Because if you have two countries which have an incorporation theory, then it's easy to move a seat in a sense. It's easy. You just say, I move here from A to B, and that's over in a sense, in theory. But if you have a real seat, then it's difficult, because then you keep your real seat maybe in your country of origin, and then you can run it into problems. So this is these countries, well, lawyers in these countries are the one who are saying, well, we have an issue here, because the application of a real seat theory is not so clear. So please, at the EU level, do something so that we have a clear view of this. Now, if we look at the cross-border transfer of seat, and what appears at the EU, at the national member state level, is that most countries do not have any legislation about how to move a seat. So it's a minority of countries who have enacted laws which gives you a framework about how to move your seat from country A to country B in the EU. So this is Cyprus, the Czech Republic, Denmark, Malta, and Spain. So if you want to move from Denmark to Spain, or from Cyprus to Malta, then it should be rather easy. But otherwise, it could be more difficult. Some countries have no legislation, like Luxembourg, but it's very easy to move a seat. So it's a bit it doesn't cover all the situations. But anyway, it shows that only a minority of member states, let's say, favor so much or allow so much transfer of seat that they have legislation in this field. Surprisingly, some member states make outbound transfer of seat impossible. And here is a big surprise, UK. Apparently, once in the UK, you cannot leave. It's surprising when you look at what's happening now. But yeah, so be careful, When you're in the UK, you can only live as dead, But funny enough, Hungary, according to the study, Hungary does not let you out. Unbelievable. No, they have been slammed by 2 ECG decisions, which say you have to let people out, and they still don't apply it. So there's a real issue here. It's not acceptable, So this part is quite funny, very strange. It provides very interesting results. You will expect that Hungary, at least, will accept that you go away. No way, you stay there. So then also you have this debate, which appears in the Paul Budd, case at the European Court of Justice, which is this one. Can a member state who has a real seat theory prevent a company incorporated in this country to move abroad without moving the real seat itself? So this is a very valid question. So the ECJ will have to answer this in the Paul Budd case. So now the other issue is this issue of conflict of laws when you have a situation where you have this foreign incorporated company. So the company has its legal seat in country A, in member state A, but the real seat is in member state B. And therefore, two company laws might apply, And one of the member state applies the real seat approach. And therefore, this is a big issue. Okay, do you end up with multiple laws who are going to apply to you? If this is the case, you have a problem, If you have to apply at the same time, German and UK law, German, or maybe German Austrian would be easier, but let's say Luxembourg and Italian law, this could be a mess at the end. So it's very an issue here. So the study points that member states are divided between real seat and statutory seat. Well, it's no surprise. What is the real seat in many member states is not so clear, actually. And this is also interesting. This is one part which is not so much developed in the study, but I want to discuss here, to share my view on this. Because you have different schools, in the real seat, church, different chapels. So you have some chapels, where they say, well, the real seat is essentially where you have the headquarters, the brain of the company. So where the CEO lives, and so you need to have the CEO, the CFO, and so on. So this is one school of thought. Another is more, let's say, relaxed and say, well, the real seat is where the board of directors meet. And I would say this is, in a sense, the 19th century approach, where you have the real seat is where you have the board of directors, where the general meeting, takes place. But I have to say today, in a digital world, with online general meetings, well, the real seat is going to be hard to identify, If your shareholders are all in another country, this analysis could backfire easily. So anyway, the countries which have a real seat approach, they don't even, in a sense, know themselves, or are very clear themselves about what it is, and they are divided. Branches. So in the case of branches here, you have some issues, and we all know what the issues are. So you have a directive about registration of branches, but some member states, so the host member states, sometimes they want to apply some substantive requirements. So for instance, they will check the corporate name. So Austria is one example, it's not the only one. So if you want to set up a branch in one member state, they will say, okay, your name in your country is name whatever, but in our country it's not acceptable because there's already a company which has the same name. So it's misleading. So we don't accept this. I have to say it's an issue, it's legitimate, of course, but there's some control, but it's an issue in terms of what you end up with conflicting situations because your name is valid, let's say, in the UK, but suddenly it's not valid in Germany or in Austria. And this is an issue because then your freedom of establishment is being limited here. Now let's carry on this. Another issue is that each member state has its, as has been said by Professor Garcia Martin, has its own view about conflict of law rules. So the scope of lex societatis, what has to be subject to the law of the place of incorporation of a company, is not the same according to each country. So you have many variations. Some countries will say, well, this concept, let's say disqualification of directors, is company law in my country. But another can say, no, it's not company law, or you can say it's company law. So I apply the receipt, then you have, two rules which apply at the same time, potentially. So the rules are not the same. But now I have to come, let's say, to hard conclusions, That's where I start to disagree with the study. Well, is this an issue, really? Because at the end of the day, when I look at the study, well, I don't see so many problems. At the end of the day, most member states apply what I would call the principle of unity of lex societatis. So we don't end up really with companies which have to apply conflicting requirements. And they don't come with examples so much of this. I don't even think there was one single example, you know. So at the end of the day, okay, there's a very nice theoretical problem, but there don't seem to be any problem in practice, or not so much. Well, problems which cannot be solved. So there are some issues which are, yes, not so much, well, certainly interesting, but at the end of the day, when I read the study very carefully, well, they don't come with any clear examples of big issues, big problems. Yes, theoretically, it's a nightmare, because each member state has its own approach. So I will say that from an academic perspective, it would be nice to have one single set of rules all across the EU, but in practice, there doesn't seem to be such an issue. Okay, now let's look at the normative analysis. So I say you have two really issues to think about from this study. First one is, do we need a directive on cross-border transfer of seat? And the answer from the study, from me also, is yes. Of course we need it. Please do it. So strong support from everywhere. The only issue I will, which is not discussed in the report, which I think is valid, has to be discussed, if the Commission was to do anything, if the EU legislator was to do anything, is should we allow member states which apply the real seat doctrine to say, well, you can only transfer your seat if you transfer the real seat, which means you want to move from, let's say, Austria to UK. Well, in such case, you need to transfer your real seat from Austria to UK. You cannot transfer just your statutory seat and stay in beautiful Vienna. And I think this is a valid question, which has to be answered. My personal view would be to say that the EU legislator, if they were to act on this, well, they should accept this. If the member state, they want to limit this freedom in the real seat, this is their connecting factor. Well, if they can keep it, I would say, I think it should be accepted. And it will make a directive much more easy to accept and to vote for everybody. So they have a real seat doctrine. This is their view of the world. It has to be respected, full stop. And therefore, if they want to limit and say, well, you want to get out, you have to move a real seat outside, then okay, it's fine with me, France will be exactly on the same side, I'm sure. What is not discussed in the report, but I think I wanted to make a point on this, is the EU should not harmonize the connecting factor, I mean, the real seat of the incorporation theory. As the ECG has said, companies are creatures of national law. So it's not to the EU to decide whether Austria has the real seat doctrine or should have the incorporation theory, or France has the real seat or should have the incorporation theory, or the same thing for Luxembourg. This seems something to be decided by each member state and to be respected by the EU legislator. Therefore, don't get into this. In addition, well, maybe I'm overstating the case, but I think it would be against the treaty. Because Article 54 of the treaty makes it very clear that you have two systems in Europe, statutory seat or real seat. So if a directive were to force, one of the two systems, I think it would be against Article 54. That's my view. So don't touch this. In addition, some people want, for instance, Professor Garcia-Martin is liberal, so he's suggesting the incorporation theory, okay, as connecting factor. But today, we all know, if we come with the incorporation theory, the statutory seat, what's going to happen? In the Council, in the EU Parliament, no surprise. It's a Pandora box. So please don't open the Pandora box, because we know exactly what is going to spring out of the box, and it's not what you want or what you expect, Okay, now Rome 5 regulation, that's the proposal. So they suggest, okay, we have Rome 1. So Rome 1 is a regulation on contractual obligations. Rome 2 is a regulation on torts, issue of conflict of laws. Company law is excluded, from this. And they say, well, it's time to include company law in a sense, and to reframe all these regulations under the name Rome 5. So in a sense, it's very close to the proposal by Professor Garcia-Martin to have a new regulation. So what will be in this regulation according to the proposal from the authors from the London School of Economics? Well, first, they will come with a list of issues which are subject to the lex societatis according to conflict of law rules. And they have a list of issues which are, well, which are consensual, you know. So formation, you know, capital, all this in all member states, you know. This is lex societatis. So this is something basic. Then they say there are some issues, which are less consensual among member states. So some member states say this is lex societatis, others say this is lex concursus, so insolvency law or whatever law, and they say, okay, this issue here, this should be lex societatis, you know, derivative actions by shareholders. Well, to me, it looks like lex societatis anyway, but it's not the case in all member states. So they will harmonize some parts of what is in member states company law for purposes of conflict of laws, but which are not lex societatis in other member states. And they say, well, you should keep members, you should allow member state to have overriding monetary provision, that is essentially, you know, order public order issues. They will exclude some issues from the Rome 5 regulation. So some topics which I consider to be lex societatis, like workers' participation, they say we don't touch this. Well, we all understand why, you know. It's another Pandora box. Groups of companies should be left outside the regulation. Then they say, well, issues of lex concursus should be out, insolvency. But we have the insolvency regulation anyway, so I mean, it solves most of the problems. One issue which is interesting is misrepresentation by management. So if you lie to the shareholders and you're listed, well, they say this is lex loci delicti and should be outside of the regulation. I say, sorry, if you do regulation, at least you should put this inside because this is the one interesting part where you have some issues. Not so many, but you have some issues. Okay, and they say also there's an issue in terms of protection of third parties. So third parties, you know, we have the first directive about representation. So it applies within the member states. And you have options, essentially, within the member states about the powers which can be opposed or not opposed, limitations also. And they say, well, this can create problems when you do business cross-border. So you're an Estonian company, for instance, you do business in Finland, and you pretend you have a power. You don't have a power. So which law are you going to apply? Are you going to apply the lex societatis, Estonian company law, which says you didn't have a power, or are you going to apply the Finnish law, contract law, which say, well, you look like an agent, therefore you should be, the contract should be valid. So they say there's an issue here which could be solved. Okay, to conclude, first I will say, don't touch the choice of member states on real seat or incorporation theory. That's their freedom. It should not be touched. Leave it away. Whatever you do, if you ever do a regulation, leave it outside. And now, I would say, maybe I'm a bit excessive, but I will say, well, cross-border transfer of seat, in theory, there's no problem. But in practice, there are many. So this is a real issue, which needs to be solved. Whereas, maybe I will be excessive, but I will say, well, conflict of law rules, well, in theory, there are many problems, but in practice, there are none, almost none. So I would say it's almost a solution, you know, in search of a problem, which is being proposed here. So before you do anything, think about it. And but there are some problems, okay, tiny problems. Then I would say, instead of making a big regulation, the Commission has to focus on the most important files, I would say. Cannot, you know, spend its political capital in everything. I would say, okay, there are some issues which pop up. Why don't you just solve them by amending some directive? You think there's an issue about representation? Well, just amend the first company law directive. You see there's an issue on misrepresentation? Well, amend the Rome 2 regulation. Just make a small amendment, you know, you can do something here. Branches are an issue. Well, just amend the directive on branches. And then that's enough, you know, and just 3 small amendments and you solve 80% of the problems. So, I mean, as an academic, of course, I'm always happy to have, you know, big direct regulations and so on, but I have to be honest, I mean, if you don't need it, you don't need it, Okay, thank you.
Thank you, Professor Cornac, for this presentation and especially for the clarity of its normative suggestions. Our next and last speaker before the coffee break will be Evelyn Regner, member of the European Parliament, who will present the Parliament's perspective on the issue. Thank you. The floor is yours.
Good morning, dear ladies and gentlemen. After the brilliant introductions of the previous speakers, I would like to focus right now on the view of a member of the European Parliament. So it was quite courageous to say of the European Parliament's view, because we are so many members reflecting different positions. But of course, we also already have sort of a past joint reports, and I will a little bit reflect on that. So which law should be applicable on European companies? Companies are creatures of law, yes. But companies, and that's the, I would say, utmost important thing is, companies are acting in real life. I mean, digital and analog life is real life. And therefore, solutions, even if we are discussing them very much in theoretic problem solutions, whatever, should also reflect this real life. So companies are not acting on Mars, they are acting on Earth, and they are part of the society. And therefore, my approach is the one that whatever we are doing in company law should more or less try to incorporate the whole picture, and on the whole picture of problems that might show up are not only those in the narrow field of company law. So therefore, first of all, I mean, we all know when dealing with this issue right now that when we're taking the incorporation theory and the real estate theory, there is not the 100% clear, real solution on the one side or on the other side. So you find elements everywhere. But as I mentioned in my beginning, I mean, as companies should reflect real life, so somehow our solutions should go there. So somehow whatever we apply right now should show this, that the real company life is pictured. And so I give you quite quickly a reality check. How does the company behavior look like today? Within the last years, we have been confronted with one tax scandal after the other. Company law is not only about tax scandals, that's clear. But what we see right now is that it's more and more the use that companies are using loopholes, and therefore we are just right now in the European Parliament busy with LuxLeaks, Panama Papers, and so on. So somehow that's the dark side of the medals, and these are the black sheep. But what we have to look very carefully as well when dealing with company law is which systematically, which possibilities do companies have systematically in order to use all those differences, loopholes, those different models that are existing within the internal market in Europe. So insufficient company law and collision law not only opens forum shopping for tax jurisdictions, companies tend to shop even their court jurisdiction, the law under which their workers are protected, or the social security law where they distribute their share for workers. With regard to workers' rights and protection of health and safety, Europe only provides minimum safeguards for workers when it comes to transnational company activities. And under the smokescreen of corporate mobility measures or reconstructing companies are setting up letterbox offices, or how I like to call it, pseudo-foreign companies. Often their aim is solely to avoid workers' participation rights, health and safety standards, or strict enforcement, therefore, by national authorities. Companies that leave their real seat, the head office in a member state, and use the incorporation in another, mainly do it for profit maximization. That means minimization of all other costs. And right now we talk also about what is this fair competition. Should it be also a forum shopping competition, or should it be simply because the best business idea, the best business model, the best idea a company has leads to its success? So, well, when the audience is wondering why I'm starting to talk during a company law conference on workers' protection standards, workers' rights, and workers' involvements, this is company law too. The relations of workers with the company, with the employer, are not only an issue, shouldn't be only an issue of DG Just, but also of the employment, DG Employment, departments within the institutions. It's connected and inherent. Without the employees, most companies could shut down. So their involvement in company decisions do have a high potential to make the company decision more sustainable and democratic. The majority of European Union citizens are in the position of being employed by companies, so we shouldn't let them behind and include them when creating new rules for companies. So who is wondering right now that due to fraudulent and questionable business practices, the trust in the business community is decreasing? European citizens are blaming the European Union for making policy only for business and leaving them behind. So let's take our chance and more or less find solutions for tackling that. So what should be our common goal within company law? How do we want to create the business environment in Europe? Now it's time to rethink the aim and goals we want to reach with setting rules for European companies and companies that are profiting from our common single market. We are in the middle of the debate about the future of the European Union. The question also of the social pillar is at stake, and it's affecting European company law and needs to be put on the table as well. President Juncker was in the Panama Inquiry Committee. What did he say? Today we have another thinking. And he was referring to the latest tax scandals, which made visible how the biggest and most successful companies in the world act and are playing with the different national rules and laws, national company rules and laws as well. And those scandals made visible that if there is a future for the European Union, I see companies acting in the market fair. Fair competition is the key word. We need to make them sustainable, and we need to make them act ethically in the future. That means also more democratic. So let's more or less have a look right now on the theories, on the incorporation theory, real seed theory, and what the position of the European Parliament has been so far. Very quickly, because our distinguished speakers already mentioned what we've done as well. So the European Parliament has never been discussing a possible regulation and applicable law on companies. The discussions were always running on topics like as transfer seat, as has been mentioned, and there we already look back to a history of reports. So Lene report was mentioned, and also my report in the last legislative period on the transfer seat. Here, when you just simply compare what has been happening within the European Parliament, you can see also that EP is not referring to the transfer of the registered office anymore. So feel free to interpret this, that EP is standing in favor of real economic action, of the real seat as a connecting factor. So however we define and dig deeper right now with the whole real seat interpretation. So the transfer procedure should follow strict rules as regards transparency and information to stakeholders prior to the transfer being carried out. And furthermore, it asks for strong information rights for employees. After working intensively in the Special and Investigative Committee that were installed, the mentioned LuxLeaks and Panama Investigative Committee and so on, the members are aware how important clear rules for companies are to avoid forum shopping. They are aware of how companies misuse their opportunities in the internal market to minimize their duties and maximize their profits. No transfer of registered office only for purposes of forum, jurisdiction, or law shopping can be accepted. And already in the 2012 report on the transfer seat, way ahead of the Panama Papers, Swiss and LuxLeaks. The Parliament highlights the misuse of post box offices and shell companies with a view to circumventing legal, social and fiscal conditions, and stated that any of this should be prevented. So somehow we're already putting the fingers in the wound quite before the major scandals were popping up. So, furthermore, the House was highlighting that any transfer should not affect the rights of stakeholders, explicitly mentioned minority, shareholders, employees and creditors, originating before the transfer. So, what should be right now our agenda for the future? Where should we go? Where should we make fast progress and creating new rules? Yesterday, we learned about the implementation and progress with the interconnection of business registers. So a topic that's also exactly with this question closely interlinked with the BRIS. Today, we don't have enough comparable data on companies in Europe. Only 22 member states, as yesterday was indicated, are connected yet, and the legal consequences vary a lot from member state to member state. So, don't do the second step before have done the first step. Don't act too fast. First step, wait for the functioning of the interconnection of business registers. Ideally, the BRIS would lead in the future to a common business register for Europe. We don't have yet comparable data. The national business registers provide only information in the language of the member states. Even in Commission projects on applicable law and incorporation in other member states couldn't find a comprehensive set of data comparable for all member states yet. So, and have to go back to expensive private businesses. The application of the incorporation theory would be nonsense when we are working in the direction of a uniform, standardized European business register soon. So the last legislative period, I already worked intensively on the interconnection of business registers, shadowing the report for my group in the Legal Affairs Committee, and it was a demand already during the works in the Parliament to aim at a common register for Europe, at least for those companies acting transnational. So, why do I speak out for the real seat? I mean, with all these nuances and with all these relative, ideas we have to take into consideration as a connecting factor. Recent trends in taxation law, as well as within insolvency law, are leading into the direction to find as connecting factor the place of economic activities. In insolvency law, also a topic that is absolutely important at the moment, the Commission proposal for a new regulation bases the decision on the competent member state on the place of the center of the main interest, which is a strong similarity to the concept of the real seat theory. In tax law, the aim is to connect the obligation for paying taxes with the location of real production and value added. The tax jurisdiction where the profits are made should be applicable. You know all that. I mean, that's more or less something when reading newspapers, everybody somehow being upset with unfair tax practices, somehow is saying it all the time. So taxes should be paid where profits are made. So somehow this approach in taxation law shows analogy to the real seat approach too. So even right now for digital solutions, we are going to find a definition for the digital business establishment when right now trying to find a solution for the CCCTB, for the Common Consolidated Corporate Tax Base. So somehow you see reality is, it's not the reality that's changing, but the political reactions on reality, on the practice, how companies are acting in this world, is changing. The European company law forms, namely the SE, is following a real seat approach. Article 4.3 of the SE regulation states that registered office designated in the SE statute must be the place where it has its central administration, which is its true center of operation. Don't break this approach. And also more or less reflecting real life and what is happening. Sometimes I like to have a look into the past and learn from it. The incorporation theory was historically applied by the UK in the past to be able to apply its company law to transatlantic companies. It's a genuine approach of the common law systems, and some more market liberal-oriented countries took over the system. Well, one of the main and major countries that applies the incorporation theory is going to leave the European Union soon, as it seems after Brexit. So, and when right now, coming to the ECJ case law, when I'm going to be criticized that imposing the real seat approach would be against jurisdiction of the European Court of Justice, I need to say in advance, I mean, I'm a member of the European Parliament, so I'm not a judge. I'm one of those legislators. I'm one of those enthusiastic, idealistic persons who would like to change the world and would like to change the internal market, and who would like to work as a legislator on finding better solutions. I simply have to say, okay, then it's up to us, the member states, the members of the European Parliament, to take the chance and to change it, to reflect on all those changes that are happening right now with the examples that I've given right now, scandals, but also experiences we have because of the European reality. Due to a lack of secondary law rules, the European Court of Justice had to find its decision solely in line with the freedom of establishment. This is problematic, especially when common law and continental law traditions are clashing. The European Court of Justice is not a regulator and is not a legislator, and it's up to us to provide fair rules, find a balance, and sometimes to correct past case law. I'm a defender of the continental law approach, so somehow I don't hide that, and of the opinion that the main rules, the written law, needs to be created by the co-legislators and not the courts in Europe. So my conclusions: we must be coherent, hear and apply the law of the member states where the real activities and central administration is located. I listened very carefully yesterday, so okay, let's focus on activities, let's focus on headquarters. I think here we have so many arguments for the academic and also for the political discussion, but really let's focus on really something that reflects real life, and companies are part of real life. Companies shouldn't be allowed to split their place of registration from their real place of business, where their main head office is located, between different member states. This would help to avoid the companies are transferring their seat for other reasons than genuine business needs. It would avoid forum shopping on national legislation, and it would help to create a fairer single market with ethically acting companies, fair competition, not competing with each other through minimizing their costs of workers' health, their share of taxes, and lower costs on social security distributions, as well as to circumvent workers' involvement rights. So somehow in these areas, we need something like a joint level playing field, and competition is something that shouldn't be done by competition of national company law systems. So the Commission has been working in the direction to an enhanced stakeholder approach in the latest past. I attended the conference in June, and I'm hoping now that the stakeholder approach has arrived in European company law, including in creating a fair and sustainable business and working environment for businesses as well as stakeholders. So, while to protect stakeholders, another instrument is needed if a company mobility package is coming: a directive on workers' involvement in European companies. Article 153, workers' social rights and workers' information and participation, has been left out widely in the past. So here we have a lot to do, and you see, company law is far more than an orchidee of academics and lawyers. and those specialists in a very narrow field of law. Company law is a picture, a mirror of real life of companies, and insofar I see the Commission right now ahead of a major work, and as a European Parliament I'm already looking very much forward to finding solutions that head us forward, that companies have a chance to be more mobile, because that's something we really need. Thank you. And you see, 10 minutes left, so we have our coffee break.
Thank you, Ms. Member of European Parliament Regner, for these insights. There's now fresh coffee waiting for you in the lobby, and we will meet here again in slightly less than 20 minutes, which means 10:05 sharp, for the second part of our today's panel. Thank you. Welcome back to the last part of today's panel. Our next speaker will be Professor Mosen from the University of Antwerp, Professor for European Union Law and Private International Law, and he will have a presentation on the Lex Societatis and corporate mobility in the internal market. What room for the concerns from a real estate jurisdictions under European law? Please.
So, dear Mr. Chairman, colleagues, ladies and gentlemen, so I've been asked to address the question whether and to what extent, or according to what method, the concerns from real estate jurisdictions under EU law can be taken into account or should be taken into account. You see here the issues that I will very briefly cover, but let me say first, by way of maybe kind of disclosure, that here I will present also the concerns affected by the real estate theory and the member states adhering to it, but that myself I've written in favor of the incorporation theory as a very suitable theory for the internal market, if complemented by sufficient substantive law harmonization. I've also been actively involved in the elaboration of the GDIP draft rules on international company law, as mentioned by Professor Garcia Martin. And these rules also put forward the incorporation theory, be it complemented with a rather narrow definition of the scope of application of the Lex Societatis. Maybe also a further element to be mentioned is that I'm talking about the real estate theory, but I do not think that the real estate theory actually exists. We always talk about the juxtaposition of the real estate theory and the incorporation theory, but in reality, when you take a closer look, you see that these theories come in many colors and variations, and that in real life, in fact, all the member states have their own brand of the real estate theory or the incorporation theory, and that for the current 28 member states, we in fact have 28 different choice of law approaches. What is true, however, is that to the extent that we can talk about the incorporation theory, that over the last few years, this theory has been trending, that more and more member states have adhered to it, although there are also increasing worries about an excessively liberal approach. And one question to be clarified in the near future is, of course, what will happen after Brexit and the impact of the UK on the incorporation theory after they've left the European Union. So anyway, in fact, I was wondering, should I now act here as a kind of devil's advocate when talking about the concerns of the real estate theory, or is there room for some appropriate caveats to be mentioned when we draw the attention to its advantages? Also, I must say that when the organizers contacted me, they mentioned that I come from Belgium and that Belgium is one of those member states which still today adhere to the real seat theory, which is, of course, true. Belgium, in fact, has adopted the real seat theory already in the 19th century, and it has had a solid application up to date in Belgium, although over time, a lot of, let's say, mitigating factors have been applied, especially under the impact of some judgments of the highest Belgian courts, which have resulted in more flexibility and especially an openness to the real seat, to the seat transfer, which is somehow combined with the essentials of the real seat theory. So we have, in fact, a kind of compromise system in Belgium, which has been confirmed also in the Belgian Private International Law Code, which was adopted in 2004. At that time, I was a member of the small expert group, which, at the request of the Minister of Justice in Belgium, had to prepare a draft for the Private International Law Code. And I must admit that within that group, there were quite some voices in favor of the incorporation theory. But when we brought that forward, it was clearly and immediately rejected by the Belgian government, which made clear that it really wished to stick to the real seat theory because of concerns of combating fraud, eliminating shopping for the appropriate law, etc. So there was no doubt that the real seat theory had to be continued to be applied. Yet we were still able to opt for a more modern formulation of the Lex Societatis, with again that openness for corporate mobility, and then also within the Private International Law Code, some reference to the impact of EU law. And you see here, just by way of brief example, the pertinent provisions of the Belgian Private International Law Code. You see in Article 110, it's a kind of traditional multilateral choice of law rule determining Lex Societatis, which refers to the main establishment, which was considered a better formulation than the real seat. But then it is linked to the definition of this main establishment. And then you see that it refers to the place of administration, center of business, but also to the statutory seat, which is mentioned as a kind of presumption that the statutory seat gives a presumption of where the real seat of the company is located. And then in Article 112, there is also a provision relating or allowing a transfer of seats from a Belgian perspective. Now, that was in 2004, and I just mentioned that the incorporation theory is now trending in, let's say, European Union member states. The same is true in Belgium, because the current Minister of Justice, who himself is a renowned company law expert, is preparing a legislative proposal to reform Belgian company law as to its substantive aspects, but also with regard to choice of law, inspired by what he calls concerns of modernization, simplification, adding more flexibility, but also, which is explicitly mentioned by the Minister of Justice, by the competition for corporate charters and a wish to be able to export Belgian company law, enhancing the Belgian legal services market, and also, which is emphasized, of creating kind of level playing field in Belgium. So the idea being that at this moment, Belgian companies are discriminated when they are active on the Belgian territory and have to compete with companies incorporated abroad, but directing their activities to the Belgian market. And so the idea is there should be one level playing field, and to that extent, a change from the real seat theory to the incorporation theory will be beneficial for Belgian companies. So introduction of the incorporation theory through a multilateral reference to the statutory seat and specific procedure which would be introduced relating to cross-border seat transfer. This will be further debated also probably in Parliament in 2018. Now, I will not again dwell on the definitions of the real seat theory and the incorporation theory or the case law of the ECJ. This has been brought forward already in many presentations. What I wish to mention, however, are what are in my view the key issues underlying the choice for the real C theory or the incorporation theory. And I think a very essential element is the consideration of how do you approach a company? What is essentially a company? And there you can have a contractual approach, or you can have the approach of a company as an actor, a contextual actor. And Professor Garcia-Martin has mentioned, or he referred also to the GDIP proposal. Underlying that proposal is a liberal contractual view on the company, while another view is that of a company as an actor in itself, acting within a social and economic environment with a network of relations and interests. And one or the other option, of course, impacts also the way that company law is approached in private international law context. For example, the GDIP proposal does not mention transfer of seat. It mentions, as Professor Garcia has brought forward, the change of the applicable law, because it approaches the company as a contract. So no seat transfer, but just a change of the applicable law, which is more innocent, you might say, than a seat transfer with everything which that seems to imply. On the other hand, when you read that the Court of Justice systematically refers to companies as creatures of national law, you see there also that the Court of Justice does not really adhere to that contractual view, but sees the companies as particular actors active within the internal market, which also may shed light on its views on the real C theory and the incorporation theory. So that's, I think, a very important underlying issue. The same is true, in my opinion, for the other questions which impact the choice of law approach. How strong a link between a company and one state can still be enforced in today's global economy? What balance do we need between party autonomy in the market and market regulation? And also, to what extent are corporate laws considered interchangeable? If you consider them interchangeable, you come also close to this contractual view, which will more easily lead to a favor for the incorporation theory. But that interchangeability can, of course, result also from harmonization within the internal market. Also, when you take then a closer look to the two theories, it is often mentioned that arguments of the closest connection point in favor of the real C theory, and openness to regulatory competition argues in favor of the incorporation theory. In fact, I think this should be more nuanced because the incorporation theory has been adopted in many states which generally in private international law welcome the idea of the typical conflict justice with the closest connection, while on the other hand, the real C theory is also dependent very much on the way the real seat is defined. If the real seat is the place of decision-making, then a company has its real seat, not necessarily in a member state with which it has many effective close ties, especially not in times of digitalization. And also, member states can opt for the real seat theory, also for reasons of regulatory competition, by adding a kind of quality label to their legislation, together with more strict requirements. So I think also other concerns should be taken into account, and they're relating to the real seats theory. These are especially ideas of protection, uniform treatment of the actors on the territory, supervision of what's happening on the national territory, control versus freedom, party autonomy, which are more, of course, beneficial for the incorporation theory. Now, I think that these policy concerns underlying the real seat theory, they are not old-fashioned, they are not outdated. They are still pertinent, but of course they need to be conciliated with the general evolution of private international law and with the internal market, which goes in the direction of autonomy and favor for mobility. Also, what has to be taken into account is that the disadvantages which are ascribed to the real seat theory affect especially the companies that have a close link with that member state. If Belgium applies the real seat theory, it is especially Belgian companies having their real seat on the Belgian territory, which will suffer from less flexibility and more rigid elements. So of course, that's also a policy element which should be taken into account. Now, when we ask ourselves what room should be given to the concerns of real seat theory, we should wonder, of course, about the legality and the legitimacy of the real seat theory. Is the real seat theory legal under EU law? I think yes. There's no doubt that it is a legal theory under EU law. It hasn't been condemned as such by the ECJ, quite the contrary. The ECJ doesn't warm up to this contractual approach of companies, and it even has, as Professor Konak has mentioned, read the real seat theory in Article 54 of the Treaty on the Functioning of the European Union. So there is no legal basis in primary EU law for concluding to incompatibility of the real seat theory with EU law. But of course, what is important or can be at stake is the effects of the application of the concrete application of the real seat theory on issues of corporate mobility in the internal market. And for that reason, the ECJ has imposed a certain transformation of the real seat theory, imposing in particular the adaptation from a multilateral to a unilateral rule with mutual recognition to companies originating in other member states. So this means that in spite of its being legal, the real seat theory still is under pressure in the European Union. There is commercial pressure. The ECJ has opened the gates for picking and choosing among corporate models via Centros, Inspire Arts, and the other judgments. And in that environment, the real seat theory is not really at ease. There is academic pressure. We have already mentioned the GDIP proposal, but in 2007 there has also been a proposal favoring the incorporation theory by the Deutsche Rat für Internationales Privatrecht. There is the European Commission LSE study, and there is modernization in many member states, translated then often in the introduction of the incorporation theory. It is legal, but under pressure. Is it a legitimate approach? I think, again, there, yes. I mean, you have pros and cons, both about the real seat theory and about the incorporation theory, but it is a choice that can be taken by a member state. It is a legitimate policy choice to be taken. And here I've written, don't ignore the facts. The first ECJ judgments on freedom of establishment and choice of law date back to 1985, which is more than 3 decades ago, with Segers' avoir fiscal, even before Daily Mail. And even the Segers case, which is a kind of predecessor of the Centros case, very much inspired by the idea of autonomy within the internal market, has given rise to much complaints about real seat theory, but even 30 years, more than 30 years after Segers, member states still choose to apply the real seat theory. So that theory still must make some sense. What is also true is that all member states, even those that adhere to the incorporation theory, desire incorporation of companies, and also they wish to have some control over what's happening on their territory. In EU legislation, we see references to real seat or real seat type of connections. The real seat theory is also referred to sometimes as a default rule, for example, in the GDIP proposal, or as a connecting factor for the application of overriding mandatory provisions. And what is also true is that most of the ECJ cases where there were problems from the perspective of freedom of establishment, in fact, relate to disputes between incorporation states and not between real seat states. So also the incorporation theory has led in its application to certain practical problems from an EU law perspective. So if the real seat theory is both legal and legitimate, I think we should not really focus on its advantages and disadvantages, but we should take the angle from the EU objectives and interests. And the key issue is whether member states that wish to do so, can they still maintain the real seat theory without endangering the objectives of EU law? So is there still room for diversity, or is there uniformity required? And the starting point is that we are talking here about EU law, not about conflict of laws. And this may seem a kind of, let's say, academic or theoretical statement, but I think it's important because we can have a lot of debates in private international law about the pros and cons of real seat and incorporation theory, and these are very interesting debates. But when we talk about harmonization, about conformity of national law to EU law, we talk about EU law. And so what I will say hereafter also should be read or understood in the framework of EU law and its particular requirements and impact. And then you touch on issues of institutional law of the EU, the legal basis relating to the area of freedom, security, and justice in Article 81, or relating to right of establishment in Article 50 of the Treaty on the Functioning of the European Union. Also, I think there are some issues and paradoxes in the debate to make us, which can make certain things delicate. First of all, it was mentioned by Professor Konak this morning, the ECJ has, since 1985, interpreted the current Article 54 of the Treaty on the Functioning of the European Union as a clause which incorporates the real seat theory and incorporation theory. It has mentioned the factors mentioned in Article 54, registered office, principal, place of establishment, central administration place, as choice of law connecting factors. While when you read Article 54, it does not talk about private international law. These factors are mentioned there as delimitation factors. They decide on the scope of application of freedom of establishment. And they require a link with the EU as a whole, not with a particular member state. Still, the ECJ has said, well, this article mentions these factors, and it mentions them as connecting factors, as a result of which both the real seat theory and incorporation theory, according to the Court of Justice, have a basis in primary law. To me, as such, it is unconvincing when you read the treaty. But of course, it has been a very smart move by the ECJ, because as a result of that, it has avoided any choice between those two theories. But this has determined the whole debate, I think, since 1985 and still today. And so as long as the ECJ adheres to that definition, we have to deal with both theories also necessarily within the internal market. Also, the definitions of real seat and incorporation theories are not that clear. You also have member states which adhere to the incorporation theory, but which are really not in favor of mobility. This morning, the example of the UK was given, which we see as the typical incorporation state, but which is not very much in favor of corporate mobility. While on the other hand, you have real seat member states which adapt this system in order to admit or even stimulate cross-border mobility. Then we always have to be careful, especially when making harmonizing legislation, on the close link that there is between conflict of laws and substantive company law, which in the LSE study is called the so-called reserved area for the member states. They are really intertwined, and you really have to be careful what belongs to choice of law and what belongs to substantive law. And very important, I think this is crucial when harmonizing legislation is made, is the definition of the scope of application of the lex societatis. For example, as has been mentioned by Professor Garcia Martin this morning, the GDIP proposal has a very narrow definition of the lex societatis, as a result of which the incorporation theory can be put forward without this impacting in any way, for example, labor protection, tax issues, other social concerns, etc. Also, when we talk about real seat concerns in the EU and how to give effect to them, we have to distinguish between the two possible legal bases. Article 81 of the treaty, which gives a legal basis for harmonization of choice of law, and Article 50, which gives a legal basis for implementing freedom of establishment. As to Article 81, in fact, this provision in the treaty is not in the chapter on the internal market. It aims at enhancing judicial cooperation in civil matters having cross-border implication, particularly when necessary for the proper functioning of the internal market. So it can be linked to the internal market, but not necessarily so. Also, the article says there is a legal basis for the EU legislator to act in order to ensure the compatibility of the rules applicable in the member states concerning conflict of laws. It does not mention that this should be or must be full harmonization of the choice of law rules. Also, of course, this has to do with the institutional framework. For example, the subsidiarity principle. In fact, the EU legislator, when adopting Rome I, Rome II, and the other choice of law regulations, has given very little attention to the impact of subsidiarity and proportionality. I think it has been inspired by the ideal of private international law of bringing international harmony. But there are other models of harmonization than the full uniformity of choice of law rules. For example, in the United States, there is also an internal market functioning with cross-border actions of companies, but without harmonization of the choice of law rules. Also, the ECJ, in its judgments, applies a kind of harmonization model which is essentially based on coordination and mutual recognition, but not on uniformizing the choice of law rules. So the preliminary question is, should we really have a unification of the lex societatis? What are the arguments in favor of a new Rome regulation? The main argument is the great divergence of choice of law rules. Yet you see there are, I think, also a few, maybe not counter-arguments, but a number of caveats to be taken into account. Yet I think, to be brief, that the overall response is yes, that due to the great divergence on this matter and its impact on the functioning of the internal market and EU integration, it would be wise to try to have a common approach of the member states relating to international company law. What should that approach be? Well, as today we have 28 different approaches, it will not be that easy to find one uniform approach. And one could choose for the real C theory. It has been mentioned in the LSA study as well. In spite of all the doubts relating to the real C theory, if all the member states would, or if it would be imposed by a regulation, that would be no problem. Then there would be no problem from an internal market perspective, as long as all the member states then apply the real C theory. They could as well also apply the incorporation theory. But maybe it's better to look for a kind of, let's say, compromise. And there are different models possible. For example, you could combine the statutory and the real seat connecting factors. For example, imposing the incorporation theory as a general rule, but have the reference to the statutory seats complemented by some real seat link which must be acquired. Or to have a distributive approach, applying various theories to various issues. For example, the existence of the company to the statutory seat and its functioning to elements of a real seat theory. You can also have a presumptive approach, as we have in Belgium, where there is a reference to the real seat, but which is implemented through a reference to the statutory seat. Restricted party autonomy is also an option. We equate the incorporation theory with party autonomy, but in other choice of law regulations, party autonomy has been restricted, for example, relating to family law. Parties can choose the applicable law, but their choice is limited to a particular number of laws that can be applied. We could think of such a model also in company law. Incorporation theory, but only applied for intra-EU relations and not giving it a universal application. Incorporation theory, but then with a more precisely defined abuse exception. Also, that is a possibility in order to heed to the concerns of real estate member states. Or, and this approach has been followed by the GDIP, the incorporation theory, but with a reference to the real seat for so-called overriding mandatory provisions, so that in the end you have a kind of balance between party autonomy limited by important interests, mandatory interests from the real seat states. So it is not black or white, and I think it would be wise to leave the heated debate between real seat and incorporation theory and to look for some kind of middle way, which would mean that eventually we would not say we apply the real seat theory, but maybe we can introduce some real seat criterions or some real seat elements within an approach that is focused on autonomy and mobility. The big question then, of course, will be to make this approach sufficiently precise and to ease the concerns from real seat member states by providing a transparent system, a balance between autonomy and real seat concerns. The other provision, besides Article 81, is Article 50, giving a legal base to the EU legislator to adopt directives in order to implement freedom of establishment. This clause could be referred to for harmonizing cross-border mobility issues. This can be, but it is not necessarily tied to the harmonization of the choice of law factor. This could be done without harmonizing choice of law, although if anyway possible, politically speaking especially, it would be recommendable to have one company law package with these various elements. Although, of course, one should be careful because Article 81 and Article 50 are not parallel provisions. They are different in a number of respects. For example, you have opt-outs in the application of Article 81. It has a different scope of application than Article 50. So one must be careful. But if there could be a harmonization of the choice of law connecting factor on the basis of Article 81 in one package with substantive and procedural harmonization on the basis of Article 50, I think this would be an asset. One example of such an approach can be found in the GDIP proposal. One key issue, I think, for this whole debate will be the judgment of the ECJ in the Polbut case. Does the mere transfer of the registered seat fit within the freedom of establishment? Personally, I think that the opinion of Advocate General Cockott takes the right course, that you cannot say that establishment interpreted as the genuine or the pursuit of genuine economic activities, that a transfer of the registered seat, of the sole registered seat, without any transfer of activities, can be brought under freedom of establishment. But of course, if it is considered that there is a right to the transfer, the mere transfer of the registered seat within the internal market, I think this will change the whole ballgame. It will lead to a very different vision on regulatory competition within the internal market. Today, there is regulatory competition, but what I would call a kind of safe regulatory competition with a lot of safeguards, etc. But if such a right to the transfer of the registered office would be adopted, it will change that and it will enhance regulatory competition. But also, I think it will threaten the viability of the real seat theory, because what member state would still adhere to the real seat theory if companies can just transfer their registered seats by going to the notary to another member state and then continue their activities on that territory? A member state that would do so would really hurt the interests of its own company. So I think if the ECJ in Polbut would take that course, it will have quite an impact on this whole debate of real seat theory and incorporation theory. Not maybe from, let's say, a legal perspective, because real seat theory will still remain legal, but as to its practical consequences, I think it will become quite less popular in the member states. Okay, thank you very much. That's all I wanted to say. Thank you.
Thank you, Professor Marissen, for this really very instructive and detailed presentation. Our last presentation for today will be the contribution by Professor Eduardo Traversa from the Université Catholique de Louvain. And he will be presenting on tax law issues, namely corporate mobility in the EU, the tax perspective. Thank you.
Thank you. Good morning. First of all, thank you to the organizer for inviting me. Second, I owe you an apology. I'm a tax lawyer. Nobody's perfect. I'm sure most of you have dreamt of a best appetizer before lunch than a tax discussion. Nevertheless, I'll try to be as entertaining as possible. I just published a video on taxation and happiness on YouTube, so I've got some experience in it. And I'll try to identify how the tax discussion fits in the company law discussion about cross-border mobility. With the first caveat, we should try to keep both areas as distinct as possible, because the policy implications are quite different. We shouldn't mix the both areas, but nevertheless, we have to be aware that there are interactions. My speech will be divided in 4 parts. As an introduction, I'll try to briefly refresh your minds about what are the implications for tax purpose of what we call residence in income tax, so the equivalent of seat for company law. Then try to sketch what are both for member states and for taxpayers the problems within the European Union arising from the lack of harmonization, of coordination of domestic rules about residence. Thirdly, I will try to sum up what are the different developments, both in the case law of the Court of Justice and on the legislative side in the area of cross-border tax mobility. And then I'll give a few recommendations about the direction that should be taken to enhance integration from a tax perspective on cross-border mobility. First, what is the function of residence in taxation? It's very different from company law, because when we discuss about the function of residence for tax purposes, we just discuss about one of the connecting factors that are used internationally to allocate taxing powers between states. It's just one of the factors. It's not an exclusive factors. Nevertheless, although it is one of the factors, it's certainly the most important one in domestic law, because usually there are notable exceptions like France, but the rest of the member states will consider that when a company is resident for tax purpose in a member state, it can be taxed by this state on its worldwide income. And then will come the application of international agreements. So in most of the cases, there won't be actual taxation of the worldwide income because of international agreements, but according to domestic law, residence is the connecting factor in most of the cases that will justify worldwide taxation, so taxation of income wherever it may have been sourced. Another function of residence that is used by member states, it's to impose withholding tax obligation on payers of income. Most of the time, investment income, interests, dividends, royalties, but also wages. So there is a second function to residence in most of the member states. But as I said, and especially within the European context, where member states have signed double taxation agreement between themselves, always on a bilateral basis, but more or less all the bilateral relations are covered within the European Union. And it's not the only connecting factors, because, for example, as regards business income, member states share the power to tax business income between the state of residence and the state of the different permanent establishments, and where those permanent establishments are located. In other words, branches, which makes things, let's say, a bit less complicated in the tax world, because since we're not discussing about an exclusive power of taxation, and there is some sort of sharing mechanism, a compromise is easier to reach. And I anticipate a bit the conclusion. I think it's the direction we should try to follow. So redefine what taxable presence is in a country is, independently from the residence. But, and here are the problems, residence for tax purposes is, as it is the case in company law, also an undefined concept at the international and European level, which means that national legislators are free to determine what is residence for tax purpose. And it's not a surprise after what we've heard this morning. There are countries that will base tax residence on incorporations, and others that will base tax residence on what center of effective management, as we call it, place of effective management. So both a formal and a substantive criteria. Nevertheless, most of the countries within the EU tend to use both criteria. And you could discuss whether incorporation comes first, most of the time, let's say, as a presumption of residence, and the center of effective management comes as an anti-abuse rule, or whether both criteria are used equally. But let's say that apart from countries like Finland and Estonia, I checked this morning, most of the European countries do not use solely the place of incorporation to establish tax liability on the basis of residence. Outside Europe, there is a quite big neighbor which use the place of incorporation for tax purposes, which is probably one of the main causes why there is so much room for tax planning between the US and some European countries. The United States used the place of incorporation as an exclusive factor to determine tax liability. And this is, for example, one of the fundamental elements that the Apple company could rely upon in order to establish the structure between Ireland and the US that was attacked by the European Commission under the stated rule. So most of the states will use both place of incorporation and a substantive criteria. And as regards the substantive criterion, there is no uniformity either. So some countries will tend to be quite formal in addressing the issue of substance. Like countries like Belgium, for example. They look at, and I'll give you more examples about Belgium, but basically where the Board of Administrators meets, which is quite formal to determine substance. Other countries will focus on senior management, which is, for example, the case of Germany. Common law countries have their own criteria which reflect more a substantive viewpoint, the concept of central management and control. And you have also other countries who have their own criterion, which is different from the other countries. For example, Italy uses also, as a supplementary criteria, the place of main object of business. So try to determine the place where the real, true economic activity takes place, but it's not that easy, even for tax purpose. There are even countries like the Netherlands which will determine tax residence according to the circumstances. So leaving a large room for maneuver to the tax administration. So great diversity. For example, and that's just, I take Belgium as an example, the criteria that are used to determine tax residence. You can see, so registered office. The most fundamental criterion, board meetings, shareholder meetings, and other supplementary criteria that as such will not be enough to establish alone tax residence, but that are taken into account. And for example, the residence of the shareholders, which as such is not a relevant criterion, but put together with others, can lead the tax administration to, at the end of the process, consider that a company is resident in Belgium. And of course, the fact that the company has no presence whatsoever abroad is also an indication. These are the criteria used by Belgium. Other tax administrations will use other criteria. Nevertheless, there is some uniformity thanks to the existence of common concept in international double taxation conventions. Most of you know that although we do not have European harmonization of, like in Social Security, for example, of connecting factors in the area of income tax, there is some indirect coordination through the OECD, which has published 40 years ago, 50 years ago, a model that most of the countries in the world, and especially OECD member, use in their bilateral relations. They may adapt the model, of course, but most of them tend to follow it almost at 100%. And in this model, you find not a common definition of residence, but a provision used to solve double taxation problems arising from situation of dual residence. So it's not a surprise, of course, that considering the great diversity of criteria used by states, that sometimes companies end up being considered resident for tax purposes in 2 or more countries. And the OECD model offers guidance so as to solve the problem, and the criterion used is, in the model, the center of effective management, which leads to consider that countries, even countries that use both criteria, but that have signed double taxation conventions, which use the center of effective management as a tiebreaker rule, are more favoring the criterion of place of effective management. An important caveat is the fact that there are discussions at the OECD at the moment to delete this tiebreaker rule, because it may lead to tax planning, since center of effective management can be determined in quite a formal way. So border meetings, it has led in the past. We discussed yesterday at dinner with Professor Garcia Martin that some directors of big Spanish banks sometimes had very heavy weeks attending four boards in 4 days, respectively in Bermuda, the Cayman Islands, Panama, and the British Virgin Islands. So after that week, they were exhausted because it was so much work that they had in order to manage 4 companies, 4 subsidiaries of these Spanish banks abroad. Of course, doing that, so fly in, fly out meetings, for most of the countries, this will be considered as sufficient to consider that the place of effective management is located abroad. But it was considered too dangerous by the OECD to keep that concept. And therefore, the OECD recommends now that the model be changed and that situation of double residence be solved by mutual agreement, which means in text that never be solved, by mutual agreement between contracting states. Almost impossible. It's hard to imagine. States are not that polite to say, do you want to tax? Okay, you want to tax. I will refrain from taxing. And so it's not very workable, although the OECD leaves the door open and proposes some criteria to be used in discussing by mutual agreement where a company is resident. And it is true that when you read carefully, the place of effective management hasn't disappeared completely. But that's just a change in the model. So at the moment, most of international agreements in force between EU member states use this tiebreaker rule. What are the implications of corporate mobility for tax purposes within the EU? For taxpayers is, taking the negative side of it, it's legal certainty and international double taxation. And I think it is important to keep this perspective alive, because at the moment, political discussions at the EU level exclusively focus on other aspects, and in particular the fight against tax fraud and avoidance. Legal uncertainty is something that taxpayers do not like to live with, and international double taxation either. It remains still a big problem within the European Union that member states haven't been able to agree on a comprehensive way of solving double taxation issue from a substantive viewpoint. They reached an agreement many years ago on VAT issue, so double taxation in VAT within the European Union is extremely rare. They just agreed upon a procedure, and that's new. They just agreed about a procedure, an arbitration procedure, in order to solve, in general, double taxation issues. We'll see how it works, because it's just an administrative procedure, so an arbitration procedure, without clear criteria. And so it will be very difficult, but now the framework exists, so it's quite positive. But still, at the moment, and until this directive on arbitration enters into force, there are several situations where the taxpayers do not know where they are residents. It's the issue of international groups of companies, which are clearly controlled by the parent company, and where subsidiaries have a reduced autonomy, and therefore, even if you, as a group, you want to have to comply with the domestic rules of all the countries where you are located, it's very difficult to understand them and to understand their interaction. And then there is the issue of digital presence, digitalization, what happens with meetings that are that take place virtually. And of course, the other issue are related to fraud and avoidance, the fact that for some items of income, residence play is used as an exclusive criteria. And it's in particular the case of interest and royalties. There is even a directive which does not allow the state of the payer to tax those interest and royalty. So for that type of income, which are quite commonly used in international group of company and royalty, especially in the digital world, there is an issue because you transfer the residence, you take with you your patents, you go to a country where patents benefit from a preferential treatment, and now quite a lot of EU states offer this treatment, and you make substantial tax gains. Then there is the issue of the taxation of capital gains. You move your seat, you move assets, and you try to avoid the tax on the capital gains on the subsequent sale of the assets. And there is quite a lot of case law on the topic. The issue of dual non-resident companies, so sometimes you have double taxation, but sometimes you have also double non-taxation. That was the case in Apple, an Irish company incorporated under Irish law and effectively managed from the US. This company was not recognized for tax purposes, nor in the US or in Ireland. The profits ended up in Bermuda. So it was the new Bermuda Triangle, expanding from Cupertino to Dublin, and where all the foreign profit of Apple disappeared. And the issue of letterbox companies, which is a tax issue, is also a social security issue, labor issue, creditors protection. Current state of European Union law, I won't bother you with all these cases. It's like a saga, the new Game of Thrones. Each year you get a new episode. So there is, of course, the prequel, the Daily Mail case, but that's prehistorical almost, because now things have changed. You have different types on cases concerning exit taxes. But before, let me be very clear on that. When it comes to taxation, the tax lawyers will first look at company law. When it comes to exit taxation, the fact that assets move when the seat moves will depend first on company law. Is it possible to transfer the seat in domestic law? If it's not possible, there is no real tax issue, even from an EU perspective. If it's possible from a corporate perspective, then we'll see whether the tax rule applicable to this operation are in line with EU law. So, capital gains, the slides are self-explanatory. It's important to have in mind that the court has evolved from a position where the fact of taxing the transfer of assets when moved from one member state to another was in principle contrary to the freedom of movement, to a position where the fact of taxing those assets when they leave the country is in principle admissible, because the court, along the years, has become more and more aware of the fiscal interest of the member states. And so the first cases, not Daily Mail, but for example, National Grid Indus, the first cases tried to put in evidence that in principle it was not permissible, with exemptions. But the last cases that we have, and now the last case of the saga is due on September the 17th. It's about the transfer of seat of a trust, so a person without legal personality, if I may say so. But there were several others where the court has now established, so we'll see what the court will say on a trust, but now the case law is quite settled. Exit taxation is permitted. And member states have the choice whether to ask the taxpayer to pay at the moment of the movement, or to give the possibility to pay in several years, 5, 10 years. So the case law now, I would say, is less favorable to mobility, at least when it comes to companies. Apart from the case law of the Court of Justice, there are some attempts to harmonize part of the regime on exit taxation. The oldest attempt was the merger directive, the merger directive, which deals with the transfer of seat, but only of a European company, Societas Europea, and European cooperative companies. So it's quite a limited scope, and moreover, it deals with the transfer without addressing the issue of transfer of assets, because for the directive to apply, basically all the assets have to remain in a permanent establishment in the country of origin. So in a sense, the directive has to be mentioned because it addresses the issue of transfer of seat, but it is so restrictive that it is almost useless when it comes to dealing with the real implication of a transfer of seat from a tax perspective, which is the transfer of asset. This is not the case of this more recent directive of 2016. The name is already a program, Anti-Tax Avoidance Directive. So it is clear that this directive does not deal with freedom of movement. The directive deals with measures that are aimed at reducing transfer of untaxed profits between member states. And in this directive, which aims at implementing OECD recommendations, you find, with quite unusual because it's not mentioned in the OECD recommendation, a provision on exit taxation, which basically implements the case law of the Court of Justice. Exit taxation becomes mandatory, so member states have to provide in their domestic legislation a way to tax assets that are transferred, in the case of a transfer of seat, for example. And that is more interesting from a mobility perspective, the country of arrival has to recognize the value used by the country of origin in taxing those assets. So the difference between the value, the market value, and the value that the assets had when they entered the company. And this is interesting because this is a coordination provision, which should reduce the risk of double taxation, not eliminate, because there is the possibility for the state of arrival to challenge the market value, but still there is the obligation to recognize the value if it corresponds to the market value. So where are we going? And that will be my conclusion. As such, further harmonization of company law instrument should not impact the existing provisions and case law on the tax aspects, because they will remain. What I already said, but seems very important to remember, cross-border mobility from a tax perspective is not just an issue of tax avoidance. It's also an issue of tax avoidance. But it has to be taken into consideration that one of the objectives of the European tax integration is to solve double taxation issues and to introduce a coordinating mechanism. What can we expect in the short, medium, and long term? I conclude with that. If we really want to solve issues related to the tax implications of the transfer of seat within the EU, what we could do is either amend existing directive. It's not a good idea to introduce tax provision in company law directives, because you have already directives, tax directive addressing the issue. It's probably not a good idea to amend the merger tax directive to extend the scope to all transfer of seats, because you have already the anti-tax avoidance directive. Now, it's also not a good idea to adopt an ad hoc instrument. So what you should look at now is first wait how the provision on the exit taxes in the tax avoidance directive of 2016 that has to be implemented in 2019 will work, and if there are problems, maybe to fix them. There are a comprehensive solution that would make the transfer of seats totally irrelevant from a tax perspective. It's the harmonization of the tax base, which has been proposed by the European Commission in October. It's a relaunch of a previous initiative, of a 2011 initiative. Of course, it's very difficult to imagine that all member states will agree. It's even difficult to imagine that some member states will agree. Even difficult to imagine that any member state will agree. But it's on the table. And then you have to think about the long term and dream a bit. But if you really want to make corporate mobility much easier within the European Union, it's a lapsus, you have to think about the United States. And they have now a corporate tax at the central level. That doesn't mean that the revenue have to go to the European Union level. You can imagine EU tax redistributing 90, 95, 99% of its revenue at the level of the states. But that would be, from a mobility perspective, the easiest solution. If you want to tackle the issue of transfer of residence, a lighter way, and I'll finish because I'm exceeding my time, a lighter way, which is, according to me, the best way to solve the actual problems, is to redefine what is a taxable presence independently from the seat or the tax residence, what is a taxable presence in a country? Because at the moment, we have this old concept of permanent establishment, which is mostly based on industrial or commercial activities that were easy to locate, and it absolutely not in line with the digitalization. So we have, and that's one of the priority of the Estonian presidency. There is a lot of work, and it won't be easy, but to work on what is a digital tax presence, to better use the criterion of sales in a country to define taxable presence, to dare to propose sharing mechanism. Because as long as you will think that it's easy to decide for an exclusive criterion to allocate taxing powers on profit that were generated out of the coordination of different people, different elements of a business in different states, you will never find a solution. So revenue sharing and a clearer definition of digital presence, that is what is to be done now, and probably not discussing about a harmonization of corporate tax mobility and a tax regime for the transfer of seat. These were my conclusions. I thank you for your attention.
And thank you, Professor Traversa, for this indeed very detailed overview. We have now about 15 minutes left for questions, and this last part I would just like to introduce with a very, very short look at the poll. Exactly. Which, as you probably realized, had not to be taken too serious here. Yeah, correct answer was C. It is not that simplistic, so. Anyway, let's really start with the questions, especially since we don't have that many time left. Yes, I think you were first. The lady in the second row. Yes.
Yes. I'm from the European Commission, and since the conference is coming towards an end, it's our last chance to squeeze some conclusions out from you. So instead of concluding ourselves, I'm asking you, there have been diverging opinions that a combination of real estate and incorporation or don't impose either. Would you see that beyond the general principles of stating that legal certainty is needed, coordinated approach is needed, is there concretely something where you see common ground? So that's to all the speakers. Thank you.
Yeah, who would like to address this first? Yeah, Professor Meisen, if you wish to.
Well, it's not that simplistic. Yeah. Well, I think there are different issues. The first is, do we need harmonization of choice of law or not? Here, I think at the table there was no common ground. As you pointed out, that would better be left just to the member states. But I think Paco and myself are in favor of EU action. We both worked on this GDIP proposal, which we see as something which could form a common ground for the member states, as it incorporates the incorporation theory balanced with real estate elements through a general clause for the overriding mandatory provisions, and then some other specific provisions that take heed of special concerns of the member states. Also combined with, and I think that really is crucial, a very precise definition of the scope of application of that measure. Because we often seem to talk about de lex societatis as if this is just one concept which is generally shared, which is not the case. You can have very different substance given to the definition of the lex societatis as to its substantive scope of application. I think if you would try to have in one choice of law instruments a broad scope of application, including labor law elements, personally I think it will be politically impossible to get to a consensus. But if you would combine a more narrow scope of application with then a directive that can take into account substantive concerns, there could maybe be a ground for a compromise. That's my opinion.
So since I'm a bit of the overview, I will a bit react. So we come from two different worlds because my two colleagues are from the conflict of law world and I'm from the company law world. And this also might have some influence. So I have nothing against, the very nice work which has been done actually, by the GDIP and also the idea of Rome 5 regulation. I think it's very logical, but it's an issue of priority, When I went through all this 350 pages study, well, I don't find really very hard evidence But the issue is so burning that the Commission has to come and do something. Whereas we have been dealing with other issues where we know it has to be fixed, which is the cross-border transfer of seat. So I'm more in the view of, priorities. I don't mean it's bad. I mean it's nice. It's a nice work, and it will be better, of course, if you have more legal certainty. So I'm not against in principle. It's not the idea. I just mean, well, I don't see so many problems which pop up. There are some problems, okay, but not so many. And if you want to fix them, I gave 3 points which pop up in the study. Misrepresentation for branches, and was the third one. And then you can fix this easily just by amending, some directives here and there. So without having all the burden, to come with a new regulation and start not from scratch, because of course the GD proposal is very good. So this is just my view. It might not be such an opposition about what to do, but is it really the time frame? It's why spend your energy here right now? That's my point.
Yeah, thank you. Yeah, I think you were first indeed, yes.
Catherine Catiard, lawyer. We see in practice companies which are registered in the business register of 2 different member states at the same time. And they say that as individuals they can have 2 nationalities. I would like to know the opinion of the European institutions and the university on this situation. Thank you.
Crazy.
Okay. So this exists in Luxembourg. But also there were some other situations. I think Fortis, for instance, the Belgian bank was both incorporated in Belgium and the Netherlands, but I think it was organized in a way that they had really 2 different, assets. So I would look at this as an example of something which works in practice, but does not work in theory. Again. So I'm a bit skeptical. I mean, to me, I heard about it, of course. This is in the London School of Economics study. So because I point this to them, and they have discussed this, but so as long as you have no conflict, for instance, between Luxembourg law and, let's say, Dutch law, because you have these kind of situations where you have this double nationality, it has to do with, by the way, with the issue of incorporation. So someone wants to leave Netherlands or UK, but they cannot. So they come to Luxembourg or to another country, which says, okay, we reincorporate you, but they are still, linked to the UK, which doesn't let them go. So they end up with 2 nationalities. That's how it happens. It's not just a choice that you want to have, 2, 3, 4 corporate passports. And as long as it can work, then okay, why not? So it's something which works in practice. But in Syria, I'm really doubtful about this idea. I have to say, I will need to think about it, really deep. But I think the comparison which is made, between the physical person and the legal entity, because you can have double nationalities, yes, you can have different passports, I think has some limits, it cannot be stretched without any limit. So I say, works in practice, but not everywhere. You could not have, for instance, a Dutch company also in the UK, because then you have issue of worker participation. If you're a Dutch company, well, you need to have half of your board of supervisors who are worker representative. So you cannot be both Dutch and UK. And to start with, in the UK, you don't have board of supervisors. So already you're dead on arrival, So whereas, in case of nationalities, well, you can have a different passport. Your body doesn't change. No, just because, you have 2 passports, you have the same body. So here you have a system where you will have 2 corporate identities, but then your body cannot adapt. So this sounds strange to me. This is so again, works in practice, but doesn't seem to work in theory.
I think this is the situation described by Professor Tagman yesterday, and if I'm not wrong, it's the same case as in the Polwood case, because in Polwood case, the company was validly incorporated in Luxembourg, and from the point of view of Luxembourg, it was a Luxembourg law, but nevertheless was still a company incorporated in Poland, and from a Polish law, it was from a Polish law perspective, it was a Polish company. And to be honest, I have a hard time understanding how the internal affairs of a company can be governed by two different laws. For instance, if you are going to make a decision in the shareholder meetings, which law applies to determine the majority that you need to pass that decision? So I would think that even in practice, it's very difficult to manage the internal affairs of a company and the two different companies' laws. I would say it's almost impossible. It's a pathological situation. That's why I think we need something to solve these kind of problems, because we cannot live in the internal market with that type of cases or what kind of situations.
If I may add something as regard the analogy with natural persons, there is the issue of the implementation. You can have two citizenships, but you cannot force a state to recognize that you have two citizenships. So you have always only one, especially so if you are in the state of one citizenship, you have one citizenship. If you are in the other state, you have the other. But it's more the issue of the implementation and the obligation to recognize, and I don't think it is possible to force a state to recognize a dual citizenship company.
To me, it looks a bit like the disease issue, you know, but it's strange. This reminds me of something in real life, but for a physical person. I had in Luxembourg Brazilian student, and during dinner time, a student dinner, she told me, "Oh, you know, I'm also Luxembourgish." I said, "This is strange, you know, because it's prohibited under Luxembourg law. You can only be Luxembourgish. So how do you do this?" And apparently, also in Brazil, you know, you can only be Brazilian. And they say, "Oh, you know, it's not a problem. They don't know about one another."
Yeah, thank you very much. The gentleman in the center had a question, yes?
Thank you very much, Bartłomiej Koch from the European Commission. One short comment and one question. A comment, I think, it looks legalistic, but I think it's important to distinguish between connecting factors. I know the court has contributed a bit to this confusion, but I think, you know, we discussed connecting factors today. We referred very much to the treaty, but there is a difference, at least in my view, between connecting factors for the private international purposes and connecting factors for incorporation of the company. I think some of the confusion comes from that. One, you can call residence requirements or incorporation requirements. When you incorporate company, then you can have a question of a real seat. I mean, would you need to have a registered office and a real seat at the same place? That's a slightly different question than what is a connecting factor for private international law. And I think sort of mixing that up doesn't always give justice to the whole debate question about real seat and incorporation theory. Now the question comes to, since I have a good long-term memory, it's mostly to Professor Garcia Martin, is when you've mentioned that about the scope of application of a possible instrument, that it should basically deal with the internal affairs of the company. We've heard already the indications about what that could imply, so also the board composition. And so how, you know, coming back to the discussion that we had yesterday when Professor Teichmann was speaking at the panel, how would you reconcile this registered office connecting factor with the employee participation? I mean, the fact that you know, the company moves to another member state where there's no employee participation, it's governed by a different law, whereas, as we've heard yesterday, Professor Teichmann suggested that it should be the law of where the company has activities which should enforce, in a way, its employee participation rules. So how would you tackle that? But this is also a question to other panelists, I mean, of course. Thank you.
I think that yesterday we more or less managed to find a solution to that problem. And as I said, for me it's the most difficult problem of this project, because obviously employee co-participation implies an interference upon company law. So we cannot apply, I think it is very difficult to apply German co-determination rights to a company incorporated in Spain. We can accommodate, but in principle, I would say it's almost impossible. So the solution to that problem is, I agree that first we have to respect co-participation or co-determination right. And then the only possible approach to that, it would be the following. Let's imagine that I am a company incorporated in Spain with no co-determination right, I open an establishment in Germany and I hire a sufficient numbers of German employees or employees in Germany that triggers the application of co-determination right. I would think that at that moment, the future instrument, either a regulation or a directive, at that moment the future instrument should somehow oblige the Spanish company to convert into a German company. Not automatically, not by operation of law, but it should be a period of time to carry out a cross-border conversion if this Spanish company wants to maintain this number of employees or even wants to go higher this number of employees in Germany. This is probably the simple case. The more difficult case is what happens if this Spanish company has German employees, but in a German establishment, but has also employees in Denmark, has also employees in France, and has employees in other member states. And in one of those member states, the number of employees triggers the application of co-determination rights. At that moment, I would think that we should, in principle, apply the same approach that we already have in the European company directive. Somehow adapted to the new instrument, as says that at one moment, first, the Spanish company should try to reach an agreement with the employees affected by this situation, not only that country, and if it is not possible to reach an agreement with that, with the employees, with the whole group of employees, then we should apply a rule by default based on co-determination, and then we have two options, either to oblige a cross-border convention of that company, if they want to maintain the level of employees, because it could reduce the level of employees, but if we are going to, if the company wants to maintain the level of employees, this Spanish company should be converted into a German company or a Danish company or an Austrian company, or it should try to modify the type of company that it is under Spanish law and take the form of a type under Spanish law where co-determination is possible. Because it is true that under Spanish law, the possibility of a co-determination mechanism, in practice, is marginal. I'm not aware of any Spanish company, it's optional, so I'm not aware of any Spanish company that has opted for the mechanism of co-determination. But somehow, this Spanish company would be obliged either to carry out a cross-border conversion and to incorporate in Germany and adopt the co-determination German law, or to transform into another type of a Spanish company which allows German employees to participate in the supervisory body of the company, German employees or other employees in other contracting state. So I think that this problem should not pollute the whole analysis of the text, because it is true that even if it is very important, if we look to the numbers, it's marginal in practice, but could be addressed and somehow solved by this kind of, I don't know if it is imaginative solution, but the kind of, I don't know, new solution.
Thank you. Mm-hmm. Who still has any further questions? Yeah, please.
Lothar Wolf, University of Würzburg. My impression from the presentations we've heard was that the differences in position are not that very strong as it might seem right now, but rather that it was the question of the scope of application. We had one position, Ms. Regner, having like the most extensive understanding of what company law is. Workers' participation, that is also company law, she said. And tax evasion, that is also an issue of company law. And on the other hand, we had Professor Garcia-Martin, who had this very narrow concept of the lex societatis, practically excluding everything which is not the internal affairs. We have the problem of co-determination under the German model, of course. I'm very impressed by your solution, by the way. But I would direct my question to Ms. Regner. Would a very narrow concept of the lex societatis work for you? One that does not touch any of the areas which you are concerned about? Also, like the tax lawyer's position was that keeping tax law separate and keeping labor law separate, as Professor Teichmann's position was yesterday, just the internal affairs, just a very narrow lex societatis. Would that work for you? Under incorporation theory, of course.
So that's important as well. So, of course, company law is company law, labor law is labor law, tax law is tax law. What I wanted to point out, and I'm absolutely convinced of that, is whatever we are doing here in the European Union is to improve the situation of all the citizens in Europe, to enable the functioning of the internal market, because it's simply good for all people. And therefore you can't go on in one field and to be too narrow in another field, or to leave it out. And what we saw, the development of the last decades, one could already see, is that when we're just simply looking at workers' participation, simply to take this issue out, because we have to debate on that also when dealing with company law, is the best thing that was happening in this sense was freezing the situation as it was. Within the European Union, we would like to improve. Within the European Union, we would like to improve situation of companies, but also of workers, of consumers, of the whole population. And insofar, whatever we are doing right now in company law has to take this whole picture. So somehow not to forget about the taxes, because I can remember whatever we were doing in company law, we just had these chapters when we left. The best thing we could reach was always to leave the tax issue neutral, not to say anything about that, because it was clear we can't advance there. If we are just pushing company law issues and to enable companies to merge and to move and to do the transfer seats or whatever, that's a nice thing. But as we are all European citizens, we would like to have the whole picture. And therefore, I'm always putting that on the table. And it's the same thing the Commission is doing right now. And we as European parliamentarians, yes, of course, we have to tackle the issue of letterbox companies because of the social securities they are not paid, the taxes and so on. But of course, to take our instruments within the company law, more or less to improve the situation. And that's it, to do it hand in hand, yeah, to deal the different issues hand in hand, but not, of course, to put everything in one company law package, because that won't work. That's clear. So we have to do something right now that enterprises can move in a more easy way from one country to the other without the whole procedures they have to respect right now, but not leaving out the other issues as well. First of all, the participation in the board, which is part of the system. It's not an annex, it's not something you just put to it, it's part of the system. And when we just look at the ECE, everybody knows 30 years it took in order to find a solution. So somehow when we're dealing with these issues, it takes time. We are already dealing quite many years, so not to wait another 30 years, so we already passed so many of them. So I think it's right now up to the Commission to propose something on a more simple transfer of seats.
Thank you very much. Unfortunately, our time is up already. We are slightly behind schedule, which does not mean that we may not continue this discussion during lunch and beyond. So I will close this panel now. I'm thanking all contributors for their really excellent contributions, also the audience for their questions. And I leave the floor to Ms. Kai Hermann, Deputy Secretary General of the Estonian Ministry of Justice, for her closing remarks.
Thank you, Thomas. We're nearly there, so bear with me a few minutes. It has been very, very interesting, and we hoped for heated discussions, and we got it. So we are very, very happy. We have heard different aspects how to move forward with the company law, European company law. And I hope the European Commission has heard also a few things and gathered a few thoughts how to accomplish their huge task they have taken to renew the legislation. In the field of digital company law, the kind speakers of the conference have shown really very many aspects what we are facing in regard of digital company law today. And I'm glad we had opportunity to share Estonian experience and explain how it works here and what are the benefits and doubts we have. And as presidency, we really would like to take this to Europe and to help diminish the differences and the divide that we actually have in Europe in digitalization in general and also in company law. We really believe, and as our speakers also stressed out, that the registration process or the interaction with the state should be as digital as possible. So the businesses actually can make business, not administrate themselves all the time. And of course, we have differences. We have, well, as the poll showed, very different and maybe even controversial aspects and thoughts how to move forward. But I think it is not constructive to talk about differences. It's constructive to talk about the common ground and maybe invent something new, something totally different, because Europe actually needs, businesses needs these kind of steps, because otherwise it is not good for the economy, and it is not good for the society in the whole. As the parliamentarian said, we have to think about the society as a whole, because everybody gains the benefits in the end. Well, we all know that in theory, the free movement of companies and the freedom of establishment is guaranteed in the EC Treaty, and it is also in the case law of the European Court that has stated that the right is there, but the details are still vaguely drawn, and this is what we are actually expecting from the Commission right now, to detail this process, because otherwise it is still different from different in different countries. And of course, last but not least, we can't go or shut our eyes on the applicable law subject. It is very important part of this legal framework to establish like a new level of EU company law. So I would like to thank our speakers very much, especially those ones who had to take the floor twice or very very unexpectedly substitute their colleagues. I would like to thank the moderators, because without them we would have been lost. I would like to thank participants, because your active participation has given fire to this conference. And of course, I would like to thank my people who made this thing possible, actually. And I'm really happy that the discussion is ongoing, and especially on political level in the parliament and in national governments. Because without without political support, there is no way forward. So, ladies and gentlemen, thank you for coming. Thank you for sharing your 2 days with us. There's lunch waiting for you downstairs. And after lunch, have a nice trip home. Thank you.